Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3.
Good morning, everyone. We have 6 arguments on today's calendar. We'll begin with appeal number 22-1876, Mohammed Ahmad versus Dodge County and others. Ms. Palmer, good morning.
Good morning, Your Honors, and may it please the Court. Megan Palmer for Plaintiff Appellant Mohammed Ahmad. Mr. Ahmad is a devout Muslim who has not missed a day of prayer since he was 7. That is, until he was civilly detained by the Dodge County Jail for 14 months. Defendants interfered with his prayer in 2 ways. First, they prohibited him from praying outside of his cell, forcing him to pray inches from a toilet, which violates central tenets of his faith. Second, they forbade him from praying with even just one other Muslim detainee, which is an essential component of the obligatory Friday prayer. Defendants had a different set of rules for Christian detainees. Christians were allowed to pray outside their cells in the day room, and they were allowed to gather on a regular basis with other Christian detainees for group prayer and group Bible study.
Which of the defendants that were sued permitted that?
We sued defendants Schmidt and Brugger on a theory of supervisory liability, and so they were not directly involved with enforcing the restrictions against Mr. Ahmad, but they are personally liable in a similar vein to this court's decision in Daniel v. Cook County, because they approved and were aware of and turned a blind eye to the discriminatory enforcement of the group activity ban.
What is your best evidence that defendants Brugger and Schmidt were aware of the disparate treatment of Christians who are doing Bible studies as a group versus the fact that Muslims were prohibited from meeting together?
Yes. So beginning with Defendant Brugger closely supervises what happens at the jail. It's his job to know what's going on there, and it's a small facility. And the record shows that Bible study was regular, was frequent, recurring, and conspicuous. And
Isn't that too much of an inference to draw? I mean, in that situation, aren't you what you're really asking for is respondeat superior liability? That you're drawing these inferences that because he was in charge of the jail, he must have known what was going on because there were only 300 inmates in the jail.
I don't think so, Your Honor, and the reason is that respondeat superior liability would mean that we would be attempting to hold them liable for anything that happened in the course of employment, so an isolated instance. This was not an isolated instance. This was a systemic, regular practice that was happening on a regular basis, and I do think that it's fair to draw the inference that he would have been aware of that. And I
Based
would point
on what evidence?
Based on the frequency of the Bible study, which from the detainee affidavits and Mr. Ahmad's testimony we know happened on a near daily basis for 30 to 45 minutes and involved moving chairs, standing in circles. It was a very conspicuous practice. And based on Defendant Brugger's testimony that he spends time in the living areas of the jail, he walks through the living areas, and he gets daily updates from his correction staff about what's going on in the jail. And this is the sort of thing that he testified would be brought to his attention in those meetings, issues that were happening with detainees.
Ms. Palmer, we know for sure, do we not, that Defendant Brugger was aware that there was no group prayer permitted for Muslim inmates? We know that for certainty because of the response to the inmate grievance that was filed in April of 2019.
That's true, yes, Your Honor.
Correct. We also know that Matt Marvin reports to Brugger, correct?
That's correct, yes.
And Matt Marvin unquestionably had quite a bit of knowledge of this.
That's true. Matt Marvin testified that Christians can pray together before a meal and read the Bible together in the day room.
Okay, so the question I have about Brugger is, how about on the personal prayer? What's the record show with as much specificity as you can articulate about Brugger's awareness of personal prayer limitations? Set aside group prayer.
Yes. So Defendant Brugger testified that it was his understanding of the policy that it prohibited all personal worship. But a reasonable jury could easily discredit that testimony for a similar reason, which is that many corrections officers and Defendant Schmidt all testified to a uniform understanding of this practice, or of this policy, which is that it prohibited prayer with a mat and it permitted prayer at a table. And so again, this is a systemic practice, a systemic understanding of the policy, and from that, a jury could infer that Defendant Brugger was aware of the way that it actually operated in practice.
Okay, I thought Brugger testified in his deposition that personal prayer can be done in a cell.
That's correct.
Right?
Yes.
But it's not clear to me that he was aware of at least your client's particular concern with praying in a cell. In other words, that there was an issue with Muslim inmates praying in cells.
Okay, so your question is that was Brugger aware that praying next to a toilet was a problem?
Right. So in other
Yes.
words, your client's challenging, right, the prison's allowance of inmates to pray in their cell. If the prison disallowed praying in cells categorically, that would be a major problem. I think everyone would agree with that way. But you need to show, don't you, to establish liability against Brugger on the personal prayer policy, that he had awareness that there was some kind of limitation with the cells that presented a problem for this particular plaintiff or other Muslim inmates. What's that evidence?
I don't think that we need that evidence, Your Honor, and I'd point to Daniel v. Cook County. So in that case, this court held that the sheriff could be personally liable for an inadequate medical care claim, even though he had no specific knowledge about Mr. Daniel's medical problem. He didn't know that casts need to come
Fair
out.
enough. So how about Brugger with any Muslim inmate?
So I do think there is evidence in the record that these complaints could have reached Brugger, and the reason is that Mr. Ahmad made verbal requests to pray outside of his cell to 5 or 6 different officers. And again, those were the kinds of complaints that would have been, because they were repeated and numerous, they would have been reported to Defendant Brugger in the daily meetings that he had with his staff. I think that's a reasonable inference for a jury to draw, and that is sufficient at this stage of the litigation. But again, I don't think what Defendant Brugger did know was that he had a policy that made it substantially more difficult for members of a minority religion to pray. And that is sufficient because he knew that the policy was discriminatory.
Talking about group prayer now?
I'm still talking about individual prayer.
Okay.
He knew he had a policy that made it substantially more difficult for members of a minority faith to pray, and that is sufficient under Daniel to find him personally liable.
Okay. Let me ask you, I appreciate Judge Kirsch is raising this question about the knowledge of individual defendants. To my eye, in preparing for this morning, there seems to be no contest. In other words, this isn't you, it's more the defendants, but they're not contesting the personal involvement of 3 of the defendants.
Correct.
That are named: Matt Martin, Chris Myers, and Scott Buckner. Is that your understanding as well?
That is my understanding as well.
Okay. So the contest, if there is one, or the dispute between the parties about whether there's adequate involvement or knowledge, comes down to 3 defendants.
Correct.
Schmidt, Brugger, and then a correctional officer and a program specialist, Jeffrey Schlegel.
Correct.
Correct? That's where the dispute is in your view?
Yes.
And then for the 3 defendants that are disputed, would you agree we have to analyze it in terms of the personal prayer and group prayer? You have to analyze it separately.
Yes.
Okay.
Although I would just point out that the individual prayer claim is solely against defendants Brugger and Schmidt. We do not sue Defendant Schlegel with respect to the individual prayer.
Oh, did you sue Marvin, Myers, and Buckner?
No.
Okay, thank you for that.
Yes.
So your individual prayer is what you're calling it?
Yes.
Personal. Okay.
Yes.
Individual prayer. The 2 defendants are only Schmidt and Brugger.
Correct.
Okay. Thank you.
And I would just like to make one more point on.
Can I ask you a question regarding
Sure.
the group prayer
Yes.
issue? The group prayer issue, what is the evidence that Marvin, Myers, Schlager, or Butler facilitated, condoned, or approved the violative conduct that you're suggesting here, which is, I think you're suggesting is allowing the Christian prayer but not allowing the Muslim group prayer, unsupervised?
That is the claim as to Brugger and Schmidt, and as we just discussed, there is evidence that Marvin was aware also of the discrimination. But for the other three, the violative conduct was their failure to respond to the requests for Juma, sustained requests for Juma, both Mr. Ahmad's and others.
But don't they have to be aware of the Christian prayer? Because there's the failure to respond. I mean, they looked for an imam, right, and they couldn't find one that would volunteer, so they said you can't do it. And clearly there's a legitimate penological interest in this. You can't allow gangs to form in the prison, right, with unsupervised prayer and things like that. Our cases, there's a long history of cases that say that. But with the other defendants, don't you have to have more evidence that they were aware of it and that they condoned the Christian prayer while prohibiting the Muslim prayer?
I don't think so, Your Honor, and I'll explain why. So first of all, I do want to point out that viewing the record in the light most favorable to Mr. Ahmad, the last time defendants looked for an imam was 6 years before Mr. Ahmad arrived at the jail, and there are 9 written requests in the record alone for Juma, to which defendants took 0 action, including not just looking for an imam, but also exploring any of the alternatives that Mr. Ahmad was proposing for other ways to offer Juma. But then also, under the free exercise clause, defendants have to make reasonable efforts to provide an opportunity for religious practice, and they must provide, this is from Cruz v. Beto, they must provide a reasonable opportunity of exercising their faith comparable to the opportunity afforded adherents of other faiths. And they were all aware that there had been no Muslim programming in more than 20 years, with a single isolated exception towards the beginning of that period. And so they were all aware that they were violating that
But
law.
is there evidence that they were aware that there was unsupervised Christian prayer occurring in the prison?
As to Schlegel, Buckner, and Myers, no. But that is not necessary for liability.
I understand.
I see that I've run into my rebuttal time.
Yeah, we're going to give you. We may need to spend a little more time here. So we'll give you your 3 minutes on rebuttal. I have a question. How do you read? You read Cruz as an equal protection holding?
I read it as a free exercise holding, but
Equal protection as well. The references to the 14th Amendment, you think they're all about incorporation of the First?
I think that it's been treated both ways in the case law. That is how I ultimately read it after spending a lot of time with the case, but I'm not entirely sure.
So let me ask you this: forget the fact pattern here for a minute.
Yeah.
What's the proper legal framework within which to think about an equal protection claim in a context like this? What are the elements?
So I think it's an intentional worse treatment of a group of prisoners or detainees as opposed to another without a legitimate penological reason for doing so.
Okay, and is that coterminous with the free exercise analysis substantively?
I don't think so, because as this court said in Reed v. Faulkner, I think that the 14th Amendment covers claims of arbitrary discrimination, and then I think the free exercise clause involves a affirmative obligation to accommodate religious practices of detainees to the extent consistent with penological aims. So I think there is more of an affirmative obligation under the free exercise clause.
Yeah, I don't know. I mean, I don't know, because the First Amendment confers an individual right? It doesn't impose an obligation upon a state actor. And you can state the equal protection analysis in the same terms. There's an affirmative obligation upon state actors to afford equal protection under the law, right? So I don't know if it's, but it's also very difficult for me. Take this fact pattern. You cannot pray in your cell categorically because you're Hispanic. It seems to me that if that's the alleged claim, hypothetically, God forbid that would ever happen, you could state a claim under the First Amendment, free exercise, and you could state an equal protection violation. You agree with that?
Yes.
Okay. You know of any case law that would suggest to the contrary? I don't.
No.
Okay. Yeah, the reason I'm asking you these questions, I'm not trying to hide the ball. The equal protection case law in the context of religious practice seems very underdeveloped to me, and it's not clear to me what the best reading of Cruz versus Beto is. I mean, I agree. If you had to put a wager on it, it's probably a free exercise holding, but it may be equal protection as well. Okay.
One question, Ms. Palmer. So we talked about collective prayer, but also there's evidence in the record of collective Bible studies, right?
Correct.
Which I think is something that's a bit distinct from prayer. And is there evidence, there seems to be evidence, is there not, in the record that the Bible studies were led? In other words, the inmates were leading the Bible studies, notwithstanding whatever stated policy they had that inmates couldn't lead group activities.
That's correct, yes.
And I know that Mr. Ahmad stated that and his observations of that in his deposition. Other than that, is there any other evidence that the Bible studies conducted by Christians were actually led by other inmates?
I believe the only evidence in the record is Mr. Ahmad's testimony. But I do think even without that, there's evidence that this was different than how the officers were treating group Muslim prayer, because even if it was just group prayer, that was exactly what Mr. Ahmad was being told he could not engage in.
I guess I'm trying to address the statements in the well-established statements in case law that approve a prison and facilities non-discriminatory policy that would prohibit inmate-led group activities, right? And so here there seems to be, at least at the summary judgment stage, evidence that the prison was allowing Christians to have group collective Bible studies that were led by other inmates, and yet using that as a reason that Muslims couldn't have similar worship services. Is that an accurate reading of the record?
Yes, that's an accurate reading of the record.
Also, it seems like for Jamal, it wasn't clear to me whether or not it was required that someone give a sermon or a khutbah during a Jamal's service. I think there was an expert that said that wasn't necessary, and there's some statements in the appellant's brief that was necessary. Can you clarify that for me?
I'm going to double check the record when I get back to my seat, but my understanding is that the sermon is a component, but Mr. Ahmad, I'll look back at the expert testimony, but Mr. Ahmad offered to conduct it in English and did offer to make many modifications to Juma to accord with prison security interests.
I have one more question to follow up on that. Mr. Ahmad testified regarding the Christian Bible studies, right? Did Mr. Ahmad or anybody else testify that any of the individuals in this case, were aware of and condoned those Bible studies, other than extrapolating from other evidence that it occurred regularly and folks were regularly in the jail? Could Mr. Ahmad offer any testimony that any individual defendants were personally aware of and condoned or facilitated any discriminatory conduct?
Mr. Ahmad did not interact with Berger and Schmidt, and so he did not have insight into their awareness. But I'll also point out that the jail was sued in 2018 over the denial of Juma. So Defendant Berger and Defendant Schmidt had reason to be on the lookout for these issues, and that's another reason that that's more evidence from which a jury could infer awareness of these issues.
Okay, Ms. Palmer, we'll give you your rebuttal time in a few minutes. Let's hear from Mr. Hall.
Thank you.
Good morning, Your Honors, and may it please the Court. As some of the questions have already indicated, We believe that this case presents a misconnection between the claims asserted and the defendants that they are asserted against. This is not a claim for injunctive relief. This is not a Monell claim. This is a claim against 6 individual officers attempting to hold them personally, financially liable. The identities of the officers, unlike what the court dealt with in Daniel, were well known to Mr. Ahmad. Throughout the briefing, we've heard about Correction Officer Cook, Correction Officer Baker, those who responded to various grievances. None of those individuals are named. This is purely an effort to impose supervisory
Can we go
liability.
through the defendants? Would you mind doing that with us?
Absolutely.
Okay. So the 3 that we talked or that I talked about with Ms. Palmer, Marvin, Myers, and Buckner. There seems to have been no contest in the district court, no dispute in the district court about their personal involvement, and it's been clarified this morning, or maybe it was and I just missed it in the briefs, that those 3 defendants, Marvin, Myers, and Buckner, are named only with respect to group prayer.
That's our understanding, and the issue with all 3 of them is they're involved with programming. So Anthony
Okay,
Marvin
where
is
in the
supervisor.
district court did I don't know if it was you or somebody else, but where did Marvin, Myers, and Buckner argue we are not proper 1983 defendants?
They did not argue it in the personal involvement section, but we went to in the group prayer section. You still have to establish that the 3 had the requisite discriminatory intent and that they violated free exercise. The 3 of them were involved in efforts to request an imam. It would have then been their responsibility to make those requests. They work as program specialists. So unlike the sheriff and the jail administrator and the other officer who had absolutely nothing to do with Mr. Ahmad, these 3 at least worked in the space.
So it seemed okay. That's helpful, Mr. Hall, because it seems like what you're saying is, yeah, they had personal involvement. It may be that they're a proper 1983 defendant, but your perspective is the claim fails on the merits, and the district court properly entered summary judgment for those 3 defendants.
That's correct, Your Honor.
Is that fair?
That's correct, Your Honor.
Okay.
So turning to the issue of supervisory liability, post-Iqbal, the instructions from the Supreme Court is to obviously to avoid the finding of vicarious liability, but to focus on discriminatory conduct, discriminatory intent. In Iqbal, in order to find liability, the decision maker has to undertake an action because of, not in spite of, adverse effects upon a suspect class. In this case, all of these defendants lack that requisite level of discriminatory intent, both on the free exercise claims and on the equal protection claims.
Okay, and why focus on group prayer for a second? Okay, if I want you to assume a fact, assume awareness of Christian group prayer. Okay, is there still not intent established on that assumption?
If the individual officer, if the individual supervisor is aware that there is group prayer going on,
Christian group
with
prayer.
Christians,
Right.
and is aware that a suspect class, a subset, a different religion is not being provided that, I think we're coming right up to the line. Like, we know, to me that seems like deliberate indifference, which post-Iqbal is not supposed to be the standard. But that, I'll grant you, that might survive summary judgment. We don't have that here.
Okay, I really appreciate your candor. Now shift to the facts. What do the facts show in your view?
The facts show that there's only one place in the record where there's discussion of Christian inmates gathering in a group to potentially, and we don't even know for sure that it was a Bible, but they all had books, and so Mr. Ahmad assumed that they were Bibles and that they were talking. None of our individual defendants, none of my clients here, were aware of that. Mr. Ahmad never reported that, the issue. And so while not directly related to this, it's still important to know Mr. Ahmad had the ability to interact with fellow Muslims. He testified in part that he would gather with other Muslims at the lunch table, talk about sermons, talk about lessons that they've learned from those sermons. They broke Ramadan fast together and would talk about those things. And so drawing the line between Juma, which is a very distinct thing, I would argue that's different than Bible study, right? That is something, to Judge Lee's question, I think Judge Lee asked this, the khutbah, the sermon that is part of it, Mr. Ahmad did seek. The concession that he was willing to make is that he would do that in English. But in his deposition, he spoke about, because of his prior experience in mosques, that he was equipped to be able to offer that sermon. He compared it in his deposition to what Sunday sermon would be like for Christians. So there was not an effort on Mr. Ahmad's part to abandon that aspect of Juma. The concession that he was willing to make is that he would do it in English. But I would say that that's still apples and oranges compared to inmates sitting around, whether they have a Bible and they're talking about the Bible. It's different than that sort of organized service.
What about if you have a Bible study where the agreement is, and I know these types of Bible studies are common, where every week one person would be responsible for talking about a particular text, right? And so I think that's kind of a commonplace thing that happens in Christian Bible studies. And Mr. Ahmad says that appears to be what was happening, right? That people would gather with books. One person would take the lead to start the meeting, to give a short discussion about the particular verse at issue. So it's not that they all gathered together and just had a group discussion. It seemed, at least if you take Mr. Ahmad's testimony to be true, which we need to at this point, that it was inmate-led.
I think if we're drawing inferences in favor of the plaintiff and accepting all of the allegations as true that are supported, I think that's right. The disconnect, though, is that Marvin, Myers, Buckner, and I would argue the other three as well, weren't aware of it.
We need to extrapolate facts to get there, right?
Yes.
I mean, in order to determine whether or not there are no facts in the record that says they were aware of it because they sat in the room and guarded it, or they condoned it by bringing the individual Christian prisoners down to a room and let them in and passed out the Bibles. So they were aware of it, they facilitated, they condoned it. In order to get there, we need to extrapolate facts and draw inferences.
And I think that's
the point I think you're making.
Yeah,
right?
that's the point I'm making, and it's impossible to do here because all of the evidence in the record says otherwise, right? Brugger, the jail administrator, testifies, no, that's not allowed. I wouldn't allow it. Multiple corrections officers that are
Schmidt says he's unaware of it.
Schmidt's saying he's unaware of it. One of the officers, I forget which one off the top of my head, said, if I saw something like that, I would intervene, I would stop, I would explain the policies, and there'd be corrective action taken with the inmate. So none of my clients are aware of Mr. Ahmad's allegation that Christians are doing this, for lack of a better term, Bible study, and there's no evidence to support an inference of that.
Okay, can we focus for just 1 second on Jeffrey Schlegel?
Sure.
Is he one of your clients?
Jeffrey Schlegel is a program specialist.
Okay,
yes.
and he's a named defendant here, right?
He is a named defendant,
Okay.
but not on group prayer.
Not on.
For group prayer, it's Marvin, Myers, and Buckner.
Okay, we got to get that. We got to get that confirmed. You sure? You're sure? Why are you saying that? You might be right, but
it's in my
I mean,
notes.
you know the case, but I mean,
That's been a difficult. There's a misconnection in this case across all of the causes of action.
so Schmidt, in your view, we'll ask Ms. Palmer this in a second. In your view, Schmidt, Brugger, and Schlegel are not group prayer defendants?
That's my understanding.
Okay, the group prayer defendants, in your view, are Marvin, Myers, and Buckner.
Yep.
Okay.
So, getting back to what about the facts in the record. So, at least Officer Marvin, right, admits or concedes that Christian inmates read Bibles together in the day room. And so what you're saying that there's no evidence, direct evidence that those Bible studies were led?
Yeah, that there's an inmate-led service that's occurring with Christians. Okay, Mr. Ahmad, if we draw all inferences from his...
I think people might quibble with whether or not a Bible study is a service or not a service. The question is whether or not those group activities were led. So the line you're trying to draw is that, sure, officers saw that there were a bunch of Christians together reading the Bible, but they did not realize that those group activities were being led by a particular person at a particular time. Is that the line you're trying to draw?
That's consistent with the deposition testimony in the case. The record shows it's similar along the lines of thought of the difference between prayer and worship. There's a general acknowledgement among correction staff that if there's an individual sitting at the dinner table and the individual bows their head, they may well be praying.
I guess I want to focus on the Bible studies, because I think Bible studies are probably more akin to services or ceremonial services, as Sheriff Schmidt talked about. And so your position is that we have officers saying that inmates got together to have Bible studies frequently. You have Ahmad saying that, oh, you know what, from my observation, those Bible studies were led. And so having those two facts, you're saying that an inference that the officers sometimes saw that those Bible studies were led is not a reasonable one for the purpose of summary judgment. Is that your argument?
I don't think there's enough facts to get us to that inference. There's not enough facts in the record.
Right, and so those two things in your mind aren't enough, that the officers saw Bible studies happening frequently, and Ahmad saying, by the way, I saw that those Bible studies were led, that those two aren't enough to draw that inference.
Well, with regard to my clients, okay, because Mr. Ahmad doesn't offer his allegation specific to my clients. He offers an allegation that there's this led Bible study.
In the day room.
In the day room.
Right. Was Mr. Ahmad asking to have prayer service in the day room?
His request was to have a prayer room, was to have a separate room to
the
conduct
day
a
room,
service.
Right, the day room is different than like a chapel. And if there are three men sitting around a picnic table in the day room reading the Bible, that's different than having a prayer service led by a priest or a rabbi in what would you consider to be a chapel or something like that.
That's certainly correct. And Mr. Ahmad himself testified that he participated in such discussions in the day room. In the day room, he would have discussions with other Muslim inmates about religion, about prophets, about
But he was not
lessons.
asking, at least the way I read, the way I understood the requests and the records, he's not asking to have a prayer service in the middle of the day room where other prisoners are watching television or playing cards or, you know, having Bible study or whatever they're doing. That's not the request that he was making.
Every request that he made sought a private room for this service.
And from what I could tell, there's nothing in the record that suggests that any of these individuals who were sued for group prayer were aware that there was Christian prayer being led by other inmates in a separate room other than the day room, such that the denial of Mr. Ahmad's request was discriminatory conduct.
That's correct. And
It's
Mr.
just
Ahmad
a
doesn't
failure
even
of
allege
proof.
that. Yes. Yes. And Mr. Ahmad doesn't even allege that. He doesn't allege the Christians gathered in a private room. All of Mr. Ahmad's allegations relate to things that he allegedly observed in the day room.
Which is different than what he requested, which was denied.
That's correct, Your Honor.
Mr. Hall, is there any facts in the record that a defendant said that was the reason that Mr. Ahmad's request was denied, that it was because, and maybe I just missed it, it's because he was requesting something in a private room versus the day room?
The request was denied for multiple reasons. Number one, there wasn't an imam to do it, but the other is the staffing and the supervising.
Right, but did any defendant specifically state, and another reason was that Mr. Ahmad requested that it be in a private room as opposed to the day room?
No, I mean, the responses to these complaints, the written complaints, of which there were two, did not go into a ton of detail as to why it was denied. Through deposition testimony, We know it was because the jail was not able to secure an imam. We know that there was concern over staffing. We know that there was a general concern among jail officials as to religious events occurring in the day room. The jail administrator testified that there was risks of offending various inmates, and the sheriff, went further to say that those types of incidents create security concerns for the jail, risk inmate safety.
Mr. Hall, let me ask you a question about how the case was litigated. Did the plaintiff offer evidence from Christian non-Muslim inmates about what they were able to do prayer-wise, where they were doing it, and how it was supervised or not supervised?
No, they did not. And they also did not develop any sort of record related to, when we turn to equal protection, turning to efforts that the jail, there's lots of criticism of jail officials for their inability to find an imam. And by the way, in Mr. Ahmad's testimony, he specifically says it would have been impossible, because now that he's out of jail, he has been to the mosque in Milwaukee, and he knows that there were only 2 imams serving 2 mosques, and it was going to be impossible. They apologized to him for not being able to get there. But my point, Your Honor, is they also didn't develop any type of record as to the efforts that jail officials used to secure Christian programming in the jail. So we know that, for example, there's a group of nuns that pretty frequently come to the jail, or pretty regularly at least. There's a Jehovah's Witnesses group that comes to the jail. There is no evidence in the record at all related to the efforts that the jail made to secure those. I'll represent to the court that those are organizations that come to the jail, and not just this jail, many jails, and just proactively volunteer their services.
Mr. Hall, can I ask you a separate question on a totally separate subject? The individual prayer in the cell. Mr. Ahmad clearly complained about that and offered a reason we could not pray in his cell near his toilet. And from what I could see in the record, the prohibition against individual prayer in the day room using a mat or something along those lines, there's these broad generalizations of security and economic concerns. But I don't see anything more specific than that. And that seems to me to be very general. Usually when there's a security concern, the prison can articulate, here is the specific concern, or an economic concern. Here is the specific, we can't afford to put a guard in a chapel to guard the chapel all day to prevent gang activity. I don't see that here with respect to not allowing Mr. Ahmad to engage in individual prayer in the day room.
So my response to that would be I believe under Turner, our obligation is to identify the basis, okay? And we have identified the basis. I'll grant you, I wish that there was a further developed record on it, but we did meet the Turner standard. The Turner standard is to identify the basis, and then the next step is there a rational connection between the identified basis and the penological interest. And here there is discussion. I mean, there is discussion from the jail administrator talking about the desire to avoid offending other inmates. That if there's a worship going on, and that is distinct from prayer, the jail handbook does not restrict prayer in the day room. It restricts worship. And so if there's worshiping going on in the day room, the jail administrator is concerned that could offend inmates of other religions.
Whose testimony do you have in mind?
Jail Administrator Brugger, and I have a cite, it is at page 60, that he discusses a desire to ensure that inmates are not offended by those rituals. The sheriff goes further to say that could pose security risks if there's issues that arise between different inmates of different religions. And I think the other thing to point out is that this is truly worship. Salah is worship. It's something different than prayer or bowing your head or meditating or anything like that. Mr. Ahmad himself described Salah as a physical prayer. The inmates in a prostrate position, standing, kneeling, going down to the ground and putting all limbs on the ground. The inmate's in an inherently vulnerable position throughout that process. and
So let
to
me ask
guarantee
you
the
this.
security. Sorry.
I'm sorry. So, you raise an interesting point. Say that you're a Christian, but you belong to a sect where for certain prayers you need to kneel. Okay? Would that qualify as worship in the definition of that Schmidt would use it, or would that be prayer?
We would have to ask the sheriff. My sense, as the sheriff defined it, as he drew that distinction between prayer and worship, in his mind, and it's always couched in, he was going to defer to, the jail administrators, the folks who are in the jail, but in his mind, he was looking at, is there loud outbursts? Is there an involvement of something else? So in this case, you have a prayer towel that's used or a prayer rug. At that point, it moves into worship as opposed to prayer. The jail did not allow the lighting of a menorah candle because of concerns over safety with fires and things like that. And so when you're moving beyond somebody who's sitting at the dinner table and may bow their head for a couple of minutes, and there's no real way for an officer to know what they're doing or not doing, as you start to move into, okay, this person's on their knees, making the sign of the cross or whatever, now okay, we're going into worship at some point. Where exactly that line is drawn, I think probably depends on the circumstances, but here with Salah, it's very clear.
Was there any inquiry made by Sheriff Schmidt to determine whether or not there was a way that Muslims can pray that would not involve a prayer rug and being prostrate on the ground?
This issue was never brought to the sheriff. So that's part of the problem. The sheriff and the jail administrator had no contact with Mr. Ahmad. He didn't even know who they were.
I guess what struck me about Sheriff Schmidt's testimony was that his view of prayer seemed like a very kind of Western Protestant definition of prayer, of what would be allowed as prayer, right? And I'm curious and that's how he defined it, and I'm curious as to whether he did any investigations about whether or not just bowing your head and speaking silently to yourself would be sufficient for prayer for any other context, say for Catholics or Muslims or anyone else.
I want to drill this point home. The jail handbook does not bar prayer in the day room. It bars personal worship. And that is the distinction.
Well, again, but you're defining prayer in terms of a Western Protestant kind of definition of prayer. And I was wondering whether there was any inquiry to decide whether or not, Muslims could pray without doing the various things that they do.
Respectfully, I don't think that definition of prayer is solely limited to Westerns and Protestants. A quiet prayer or bowing your head or meditating, those aren't unique to Christianity, and they're not unique to Western culture. It's something in the Buddhist religion, and there's 4,000 religions in the world. Westerns and Protestants are not the only ones who bow their head and engage in quiet prayer. In terms of further investigation or questioning on Mr. Ahmad, if his prayer, if his salah required going prostrate, no. The sheriff was not aware of anything related to Mr. Ahmad. The jail administrator was not. It's for that reason that they were properly dismissed from the case.
Mr. Hall, can I ask you one further question? I'll ask Ms. Palmer the same question regarding qualified immunity. I suspect that the jail, the guards in the day room had to distinguish between worship and prayer. And what I mean by that is, let's say you had a Catholic prisoner that was going to say the rosary every day. So he went in the day room, he had his rosary beads, he bowed his head and said the rosary. Now you have another Catholic prisoner who says, no, I'm going to say the rosary every day, but I have to do it on my knees, facing a crucifix, and I have to say the rosary out loud every day. That's what I'm going to do. The jail, I assume the guards then have the discretion to say, wait a minute, you can say the rosary silently with your head bowed, no problem. We consider that to be prayer. You can't get on your knees with your back turned to the rest of the pot, face the crucifix, say the rosary out loud. That could create security problems with the prisoners. Are there any cases that, in terms of the qualified immunity context, that say you can't distinguish between prayer and worship in that way that you're aware of?
None that I have found.
Okay, Mr. Hull, thank you very much. Mr. Palmer, we're going to give you at least 5 minutes. There's quite a bit to sort through here. Would you mind starting with which named defendants are named on which claims?
Yes. So as to equal protection and group prayer, it's everyone. So that's a simple distinction.
Okay. Now, is Mr. Hall just mistaken in your view on the group prayer that it's only Marvin, Myers, and Buckner?
Yes. The group prayer claim is as to all defendants.
Okay.
We talked at length about how Defendant Schmidt and Brugger were aware of the discriminatory enforcement of the policy that makes them liable for the free exercise claim based on the group prayer claim.
Okay. Group prayer, first free exercise and equal protection, every single defendant.
Yes.
Okay. All 6.
Yes.
Okay. Individual prayer, just the 2.
Correct.
Okay.
Can you go to my question?
Sure,
Are you
of
aware of
course.
any cases that say that prison officials cannot distinguish between worship and prayer? And granted, this gives the individual jail guards discretion to say you can bow your head and say the rosary, you can't kneel in front of a crucifix and say the rosary out loud. But are there any cases that say you can't do that under the free exercise clause?
Yes, Your Honor, and I don't have a case to point to with the exact one-to-one fact matching that I think you're asking about, but I'll explain why qualified immunity is inappropriate in this case. I'd first like to say that the context here is a considered jail policy in the free exercise context. This is not the fast-moving Fourth Amendment context where the Supreme Court has said that one-to-one fact matching is particularly important because of the imprecise nature of the legal standards. And in the free exercise context, we have cited cases at the right level of specificity. So the first. Again, there are 2 constitutional principles clearly established that defendants violated with this policy. The first one is that it is clearly established that a jail cannot inhibit the right to pray without some justification. And on the basis of that clearly established law, this court has easily denied qualified immunity in cases where defendants fail to come forward with a justification for a policy. That's Williams v. Lane, and then more recently in Garner v. Munchow. And in both of those cases, this court denied qualified immunity, and it said what the clearly established law is at the exact level of specificity that we asked this court to apply today, and denied qualified immunity without a exact fact matching. And that makes good sense because the principle that you can't inhibit religious exercise without some justification is very straightforward and easy to apply. The second clearly established principle is that a jail cannot have a regulation that inhibits religious exercise that it enforces against members of some religious groups but not another. That's Grayson v. Schuler. And both of those cases amply put defendants on notice that their conduct was unconstitutional in this case. I'd like to respond to a couple points that defendants raised. First, Judge Kirsch, you were right to note that defendants do not articulate a credible basis for the restriction on personal prayer in the day room. And defendants' counsel, I think this court has been very clear that in Neely Bay Tariq L, that mere incantation of a penological interest is not sufficient under Turner. You have to explain it and you have to have record evidence to support it. And there isn't any in this case. The sole citation to the record in defendant's brief is a single comment from defendant Schmidt's testimony. Much of the rest of the record contradicts that comment. And it is that more involved prayer could, quote, cause difficulties for other detainees. That's all. It is not elaborated, and it is contradicted by much of the rest of the record.
Ms. Palmer, can I ask you a factual question about the plaintiff's perspective on praying in his cell? My understanding is that his objection was praying within a room with a nearby toilet, and that he just wanted to engage in the personal prayer 5 different increments during the day in some other location.
Correct.
Whether that's here or there or the day room or the library or the lounge or wherever, it doesn't matter. His point was that I can't adhere to the tenant requiring me to pray 5 times a day in this location. I just need to be in some other location, not near a toilet.
That's right.
Was he ever specific as to what location he wanted?
No, Your Honor, not as to individual prayer nor as to Juma. I did want to correct that point as well. In his 3 written requests about Juma, he said that he wanted space to perform Juma. He didn't say private room. He said space, and that could have been the library, the rec room, the day room, or a programs room supervised by a program specialist.
But the day room, it sounds like the day room was out because there was a policy in the jail that prohibited worship in the day room. And that clearly would have been worship, right? It would have been different than prayer. In other words, there's this policy that the jail has that says you can pray in the day room, but you can't worship in the day room. And unless we find that that policy is unconstitutional and the defendants are not entitled to qualified immunity regarding that policy, then that becomes a problem if he's not requesting a separate room for the group prayer. Does that make sense?
If the policy were neutrally enforced and there was
There's no evidence that it wasn't. I mean, what you're saying maybe clarifies things, but your client was requesting space. So that means the jail needs to interpret that. I took it as your client was requesting a separate room for the prayer. But if you're saying that's not what he was requested, then I think that actually helps the defendants. Because if the defendants interpreted it as he was requesting group prayer, group-led prayer in the day room, they would say, oh, no. We never allow that under the worship policy. And that's the end of the case. But maybe I'm wrong on that. I think he has to be requesting a separate room. I think if he's requesting group worship in the day room, it makes it a much easier case for the defendant.
he was requesting group worship anywhere, and defendants could have viewed that as a request for group worship in the library or a programs classroom, and then that wouldn't have been a clear-cut case for them under the policy.
Ms. Palmer, I found the expert statement. It's the Ingram Declaration at paragraph 7, where he says, Juma customarily consists of performing the Salah prayer, followed by a sermon known as a khutbah. When there is no imam available to give the sermon, that part can be skipped. It is a gathering of Muslims to pray together at or after noon on Fridays that constitutes Juma as such. How are we supposed to weigh that in terms of, or compared to the actual request that Mr. Ahmad made, that he wanted to have a Juma with a sermon?
Well, Mr. Ahmad said that in his deposition. When he was asking for Juma, he was asking for Juma. He was not saying specifically there is a sermon component. He said there doesn't need to be an imam, and he indicated that he was willing to modify it in a way to be consistent with the jail's security concerns. What he said in his final grievance appeal was, all we need is for 2 or more people to pray together peacefully. So I think that's the request that was presented to the jail. And so we can take account of the expert's testimony. I would just like to end by saying, again, that prayer is special. It is core to the protections of the Free Exercise Clause and embedded in our constitutional tradition, and defendants denied Mr. Ahmad the ability to pray. And we ask this court to vacate the district court's decision.
Okay, very well. Ms. Palmer, thanks to you. Mr. Hall, thanks to you especially for bearing with a law and argument, but there's a lot in play here. We appreciate it very much. Okay, we'll move to our second case of the morning, appeal number 22-1835, the United States versus Angela Baldwin.
Good morning, excuse me. Good morning, Your Honors. My name is Anise Kelly, and I represent Ms. Baldwin in this matter. I would like to start with the sentence disparity. Under 18 U.S.C. 3553A6, sentencing judges must consider the need to avoid unwarranted sentencing disparities among defendants with similar records who have been found guilty of similar conduct. That is exactly what did not happen in the present case. Instead, Ms. Baldwin received a 10-to-1 sentence to defendant Russell Taylor, and it was 7.5 times higher than
He only received 40 months?
He received 27 years.
Counts don't matter. We've said that over and over and over again. The number of counts don't matter. So it wasn't a 10-to-1 sentencing enhancement. He received 27 years and she received 400 months, right?
She received 33 1/3 years, correct, Your Honor.
And he received 27. Did she cooperate?
Well, she had no opportunity to cooperate.
So the answer is no, right? So there's your disparity right there.
Well, I think that there are a couple of things about the sentencing that was wrong. One, the sentencing court referred to Mr. Taylor as abusive and controlling towards Ms. Baldwin, and yet she still found Ms. Baldwin more culpable than Mr. Taylor. The sentencing court cited the fact that Mr.
Did
Taylor,
Judge Pratt, I didn't see that in the record, did Judge Pratt say that Miss Baldwin was more culpable than Mr. Taylor?
No, Your Honor, that's my extrapolation from the sentences.
Okay.
The sentencing court also noted that Mr. Taylor accepted responsibility by pleading, but he didn't, because he appealed his first plea. He filed the 2255 motion, which he was successful on, and then he appealed his second plea, which he was also successful on. This court just vacated and remanded that. So Mr. Taylor received credit for pleading when in fact he didn't accept responsibility.
Did he challenge any facts in either of those appeals? Because I thought, you certainly appeal. His first appeal was based on ineffective assistance of counsel, which you can always appeal. His second appeal was based on the warrant. The validity of the warrant was purely a legal issue. I don't think that he's ever suggested that he didn't horrifically abuse these girls. Maybe he did. Maybe I'm wrong and I'm just missing it.
No, Your Honor, he did plead twice. But I don't think you can say someone accepts responsibility and then they continually challenge their plea.
Well, sure you can if they're challenging legal issues. They can say the facts are accurate, that the facts that you've described are accurate, but the law doesn't punish those facts. They would accept responsibility for their conduct, but they would say it's not a crime. I engaged in this, but it's not a crime. That could be acceptance of responsibility. It happens all the time. We see cases all the time where a defendant pleads guilty but reserves the right to appeal a particular legal issue. The district judge allows acceptance of responsibility, and it's not even challenged by the government on appeal.
I take your point, Your Honor. I take your point. Well, I would still argue that that Ms. Baldwin, even if you don't consider the counts, her sentence was still out of whack compared to, once again, just the individual circumstances of the case.
Ms. Kelly, let me ask you the point about the counts. I understand why you want to focus on the counts, because if you can get to 10-to-1, that's the way you can show the disparity. The difficulty I have with it is the legal support for that. What case law can you point us to saying that a proper analysis of a concern about an unwarranted disparity allows the sentences to be analyzed vis-a-vis counts? What's the best authority for that, if any?
Well, and Your Honor, I don't have good authority on that point, but that doesn't mean that this court can't set that authority at this moment in time.
No, but as Judge Kearse was alluding to, we've actually suggested to the contrary. And the reason we've suggested to the contrary is because of the U.S. Supreme Court's decision in Dean. Do you think we've misread Dean?
No, Your Honor. I guess I'm just asking a reconsideration. And I think the individual circumstances of this case, Mr. Taylor was involved in this activity for 14 years. If we ignore the counts, it's still the individual facts. 14 years of this behavior versus Ms. Baldwin, I think, was 3 years.
Okay, that's fair enough. That's a broader point, and we'll have to figure out whether we agree or disagree with you. Mm-hmm. Okay, you can continue on.
And again, I know I stated this before, but the fact that the sentencing court called Mr. Taylor abusive and controlling, I think that also is an individual circumstances that the court noted, but didn't take into consideration when it sentenced Ms. Baldwin. I'll move to the vindictive prosecution. I think that but for Mr. Taylor's successful 2255 motion, Ms. Baldwin would not have been prosecuted. Certainly there's no explanation for the 5.5-year delay. The government's stated reason is it had to wait for the witnesses to mature so that they would be able to better testify, but they haven't explained at the same time why that wasn't true for Mr. Taylor or Mr. Vogel.
So here's what I took away from the briefs. I might be wrong. You can tell me I am. That when Mr. Taylor prevailed in his 2255 motion on ineffective assistance and his prior conviction and sentence were vacated, the government took a fresh look at the entire set of circumstances, including, at that point, they had to decide whether they're going to recharge Mr. Taylor, right?
Correct.
And they chose to. And in connection with the recharging, that's when, unfortunately for Ms. Baldwin, she entered the mix here, right?
Correct, Your Honor.
Okay. And that, I'm gleaning that from what I've read in the briefs. Okay. If that fact pattern is correct, or that understanding is correct, where is the vindictiveness within it?
Well, I think the government's only stated reason for the 5.5-year delay is to wait for the victims to age.
I thought they said that. Well, they have said that. You're right about that. But they also said we just took a fresh look at the whole case, the whole set of circumstances after the 2255, and we realized, hey, there's another defendant who is quite culpable here. The statute of limitations has not run, and so they made a choice then to charge your client. I know she wishes that didn't happen. I get that. But I have a hard time seeing, at least under our case law, and I'm thinking in particular, unless you can distinguish it, our decision in 2006 in United States versus Jarrett.
Right, Your Honor. And I know that I'm asking for an expansion of the vindictive prosecution theory, but I think it's a very narrow, limited expansion that I'm asking for, in that Ms. Baldwin did not exercise her own constitutional right, and I know that in Jarrett the issue was the whole timing issue, but I think that by narrowly expanding the issue, the legal theory for Ms. Baldwin, who I would argue stands in the shoes of Mr. Taylor, because they're inseparably linked, that even though she doesn't fit squarely into the vindictive prosecution theory, I think this is an appropriate case to expand that theory.
Okay, you reserve 5 minutes for rebuttal. You want to pause now? It's up to you.
Yes, thank you, Your Honor.
Okay, very well. Mr. Reitz, good morning.
Good morning. Brian Reitz for the United States. This court should not expand its prosecutorial vindictiveness standards. The court has essentially explained two avenues to showing vindictiveness. One, certain cases there can be a presumption, but that presumption is not available for pretrial charging decisions where the executive's discretion is at its highest. Two, there has to be affirmative, or if a defendant can show affirmative, objective evidence of vindictiveness. That's not available here. So Ms. Baldwin has no choice but to ask this court to expand what this court has said for decades, and I think what every other court has said about prosecutorial vindictiveness. And Judge Scudder is right that, yes, we did mention the fact that the victim's aged, but we have also been upfront that the change in prosecutors necessitated a fresh look on everything, including if we were going to charge Mr. Taylor again, and Ms. Baldwin was there, and the new prosecutors who would not have had any animus to Mr. Taylor, much less Ms. Baldwin, decided to charge Ms. Baldwin. Ms. Baldwin was charged based on the usual determinative factors. She committed disturbing crimes, and we had strong evidence of those crimes. There was clearly probable cause to charge her, and we were not vindictive in doing so. If there are no questions on vindictiveness, I'll move to the sentencing. This court has said that disparate cooperation warrants disparate sentences. Here, Mr. Taylor cooperated against Mr. Fogel. The sentencing court found that especially compelling because Mr. Fogel, based on his fame, his affluence, and everything, would have been a difficult person to prosecute if not for someone cooperating. So Mr. Taylor's cooperation against Mr. Fogel led directly to that prosecution. And Mr. Taylor has accepted responsibility twice, and Ms. Baldwin has accepted responsibility 0 times. The court was well within her rights to consider those facts. The court has no questions on that. We'd be happy to rest on our briefing.
Okay, Mr. Wrights, very well.
Thank you.
Thank you, Your Honors. I have no rebuttal.
Okay, Ms. Kelly, I see here, am I correct that you were court appointed?
Correct, Your Honor.
We very much appreciate you accepting the appointment, your service to your client and to the court in your briefing and this morning. Thank you very much.
Thank you, Your Honor.
Okay, we'll move to our third argument of the morning, appeal number 22-2312, the United States versus Quanell Jones. Mr. Alivedo, good morning.
Good morning, Your Honors. May it please the court, my name is Peter Olivato of Notre Dame Law School. I'm here under the supervision of Attorney Bob Palmer on behalf of Mr. Jones. Mr. Jones appeals the district court's finding that he knowingly and intelligently waived his right to counsel because the record indicates that he did not understand the dangers of self-representation, the nature of the charges against him, nor other facts critical to his self-representation. Therefore, he asked this court to reverse. As a preliminary matter, and since the government has disputed it, the standard of review in this case is de novo, with a strong presumption applied against a finding of a valid waiver. Review is not deferential, as the government has asserted, because the validity of a constitutional waiver is a legal issue and not a factual one. In United States versus Balsiger, this court held, in a decision circulated to the entire circuit, that even fact-heavy constitutional waivers are legal issues to be reviewed de novo. And this brought the circuit in line with Supreme Court precedents such as Johnson versus Zerbst and von Moltke v. Gillies, that a judge ought to indulge every presumption against finding a valid waiver. Given this standard, review of the lower court's decision clearly shows that Mr. Jones's waiver was not knowing and intelligent. There are 3 specific deficiencies that we would point to, which the Ferretta inquiries were insufficient to unearth. First, Jones's misunderstanding of the nature of the charges against him, as demonstrated by his numerous statements to the court regarding the commercial aspect of the matter. Second, that Jones did not understand the full dangers of self-representation or scope of self-representation, as demonstrated by his reliance on a third-party filer. And third, that Jones's background and legal experience were insufficient for self-representation, as demonstrated by his pretrial conduct and lack of performance at trial. In the face of these deficiencies, the court below ought to have conducted further inquiry or appointed counsel over the defendant's objection.
Mr. Oliveto, the first point that Mr. Jones talked about these proceedings as being commercial. Is that a result of his beliefs and practices as a sovereign citizen? In other words, as I understand, to the extent I can, kind of sovereign citizen movement, and to the extent that it can be kind of summarized in one sort of umbrella, is that they view a lot of things through the UCC and through commercial law and common law contract versus recognizing any other authority. If that's the basis for his belief, and he stated his belief, what else could the judge have done to try to address that beyond what the judges did?
Your Honor, a few points on that. First, there was no discussion at any point in the lower court as to whether or not the defendant held those beliefs and made those arguments as a result of holding sovereign citizen beliefs. Rather, that's a label that's only been applied here on appeal. The lower court judges never made any such finding, and in fact, one of the critical deficiencies in both Ferretta inquiries was that the lower court never inquired as to what types of arguments Jones intended to present or what theories on which he intended to press his defense.
That would be pretty dangerous. I mean, I think if you're asking a district judge to say, preview your defense with me, with the prosecutor sitting right there, and let me weigh whether or not I think it's going to be good and fly with the jury, and if it is, maybe I'll let you present it, and if it's not, maybe I'll force you to have a lawyer.
Your Honor, it's not necessary for the lower court to go into any such great detail, although of course we recognize the danger there. But that is also something that there is precedent for. In United States versus Bell, for example, the judge communicated with the defendant as to what types of defenses he intended to present, and the defendant explained to the judge that he was going to present an alibi on his own behalf. And in United States versus Sandals, the judge engaged in a colloquy with the defendant over which arguments were waived by the defendant's plea and which arguments he intended to pursue in light of that plea.
Is there any case law that says that the judge has to do that?
Yes, Your Honor, not in as so many words, but in United States versus Bellinger, this court held that at a minimum, one of the aspects that a defendant must possess in order to represent themselves is an understanding of the nature of the charges and the difficulties encountered as his own counsel, one of which would obviously include having to present arguments on his own defense. And going back farther to the United States Supreme Court's precedent in Von Moltke versus Gillies, the court there stated that one of the indispensable understandings to a valid waiver was possible defenses to the charges and circumstances in mitigation thereof. So there's quite a bit of precedent stating that that is something that a defendant must have an awareness of in order to represent themselves and to forego counsel. Furthermore, Your Honors, while it is true that a strategic waiver, as the government has labeled Jones's here, typically does cut against a finding of cut towards a finding of a valid waiver, the government uses that term here merely as synonymous with an intentional waiver, and that's not how this court has treated the strategic waiver analysis in other circumstances. For example, in United States versus Moya Gomez, strategic is consistently used alongside the terms manipulative, and that has primarily been an inquiry to determine whether or not the defendant's arguments are an attempt to tie up the court or to circumvent the court in some way, and there were no findings by the lower court that this was an attempt to do so. So the strategic aspect of the defendant's waiver in this case does not cut against the invalidity of the waiver. Turning then to the third-party filer, Mr. Jones clearly did not understand the full dangers of self-representation because throughout the proceedings, through both pre-trial and post-trial, he relied upon a third party to file documents on his own behalf. And while there were instances in which the lower court rejected those filings or explained to Mr. Jones that he could not rely on those filings, number one, he continued to do so despite the court's admonishments, and second, there was never any inquiry as to what degree Mr. Jones was involved with the preparation of these filings, nor to what degree he understood the contents of those filings. And
Mr. Alvado, let me ask you that. You're not making this particular argument, and I understand why, but I'm just interested in your impression. You have concerns about his competency?
Only so far, Your Honor, that if there are concerns about Mr. Jones's competency, the first step to determining whether or not those concerns are valid would have been appointing counsel over his objection, Your Honor. So as a preliminary step to determining whether or not Mr. Jones was or was not competent, the lower court ought to have conducted further inquiry and, if necessary, appointed counsel over him, reappointed standby counsel.
The arguments that he pressed, or some of the points that he made about being a natural person, not a U.S. citizen, being subject to common law, some of the points that Judge Lee is getting at, these are quite akin to different positions that we have seen members of the sovereign citizens movement take in other cases. Banks, Janassin in particular here. How's this case different? These are very common, beliefs that are in positions that are offered by individuals that are part of this movement.
Mm-hmm. Your Honor, we would not suggest that any defendant that makes these types of arguments necessarily does so without an understanding of the nature of the charges against them or an understanding of the scope of representation. But rather, in this specific case, the arguments which Mr. Jones made, the statements he made to the court, demonstrated he didn't even understand that he was facing criminal charges, nor that he stood before a criminal court. It's entirely possible that a defendant could make similar arguments with an understanding.
Yeah, I see how you get that out of the second transcript, the one in front of Judge Mim. It's much more difficult for me to see that in the first transcript. Have I misread him?
No, Your Honor, I do believe there is a difference there in that Judge Mim conducted his inquiry with the benefit of the hindsight of Mr. Jones's filings up to that point. However, as I stated previously, one of the primary deficiencies in the first Ferretta inquiry was that it did not cover the types of arguments or motions that Mr. Jones intended to present on his own behalf. And if they had, that's something that Judge Long would have been able to more properly address.
Okay, you want to save your remaining time?
Yes, Your Honor. Thank you.
Okay, very well. Good morning, Mr. Canestra.
May it please the court. Good morning, Your Honors. Jeff Kinstra on behalf of the United States. The record here makes abundantly clear that the defendant knowingly, intentionally, intelligently, and voluntarily waived his right to counsel, meaning that he understood that he had the right to counsel as well as the consequences of waiving that right, including the dangers and disadvantages of doing that. And really at the outset, the Ferretta colloquies here are insurmountable for the defendant. They were thorough, detailed, patient colloquies where the court conveyed everything the defendant needed to know and assured itself through its inquiries and the defendant's responses that the defendant understood the things he needed to know. The defendant starts off with his argument that he didn't understand the charges against him, and as Your Honor just alluded to, that's really just unrecognizable to the first colloquy and even the second. But starting with the first, Judge Long he first ensured that the defendant had a copy of the indictment. He then he read each of the three charges, and for each charge he went through all the essential elements of that charge, confirming with the defendant each time that he understood exactly what he was charged with doing, exactly what the jury would have to find beyond a reasonable doubt for him to be found guilty of those charges. The defendant under oath said each time that he understood that. He also said that he understood the charges or the penalties he would face, criminal penalties. In arguing otherwise, the defendant is really contesting the court's implied credibility finding. As this court, to the points about the standard of review, there really isn't a dispute that the bottom line is de novo, but the factual findings are for clear error. And as this court explained in Balsinger, it too simplifies the analysis to merely observe that the constitutional question is decided de novo, because whether the legal standard is met in a given case will depend on the factual findings, and in many cases, the district court's credibility to findings. Because the district court here, Judge Long, Judge Mim, they were the ones that had the opportunity to engage with the defendant in person, to have that face-to-face discussion with the defendant, to gauge his demeanor, his credibility, the genuineness of his statements, and ultimately his understanding. And so those judges conducted these colloquies, interacted with the defendants, and ultimately made the findings that the defendant was credible when he said he understood these things. So really it is a factual dispute that the defendant's raising here, and that is something that this court absolutely reviews deferentially, as it emphasized in Balsinger itself. So getting to the second colloquy then, the defendant seizes on a remark he made towards the beginning, saying something along the lines of, "I don't understand the charges." But first, his very next words were, it's not that I don't understand the letter of the charges. And then he pivoted to saying, like, how can this court have jurisdiction against me if these are criminal charges? Because there's no such thing as statutory jurisdiction in criminal cases, only maritime, and so on. And so really this is just an iteration of his sovereign citizen sort of argument. And to the extent that there was any lingering ambiguity or lingering misunderstanding on his part, Judge Mim cured that through his responses. Judge Mim said, this is a criminal case. There is no question about that. He said that these charges are based on violations of the federal criminal statutes, that the district court has jurisdiction over those charges. And then he read each of the charges to the defendant again, and each of the penalties. Now, there's also some sort of gamesmanship or wordplay on the defendant's part, saying that he overstands and doesn't understand. That's really another example of where the district court's front row seat is all the more important. Because when these sorts of claims really present a sort of whipsaw effects, where regardless of what the district court did with this, the defendant would be up on appeal arguing that it should have done the opposite. And so in a circumstances like this, where really the defendant is sowing ambiguity in the record and engaging this sort of wordplay, it's the district judge who has the opportunity, based on his face-to-face interactions with the defendant, to gauge whether this is genuine on the defendant's part. Does he really understand, or does he not? And the court here necessarily found that he did have the understanding, and that's a factual credibility finding that this court reviews deferentially.
Mr. Kinster, let me tell you what runs through my mind in these cases, and you tell me I'm way off or how you all do it. When I see a defendant make a choice like this, to represent himself and go to trial and then do absolutely nothing at the trial, he's sealed his own fate in a major way, and it's going to cost him over 10 years of his life. Most of the time, you do not see people act so against their self-interest like that. It's rare to go to trial and do nothing that way, representing yourself. And that raises for me questions: are we sure he's competent? And I know there's no motion here under 4241. I realize all of that. Where do you see the dividing line between the ability to represent yourself and competency with respect to defendants like this? We talked about this in Jonasson some, but there's a motion there. And so we reviewed the denial of the motion. But I really wonder whether the proper course some of this time, when you see complete incoherence on display, is to not have a defendant like this observed for a period of time within the BOP to figure out what is going on here.
So a couple responses to that. First, I'd note that, as this court has acknowledged, these are arguments that are pretty familiar to the district courts, to the courts of appeals. It's an outlier in terms of the general public, but it's not unusual that criminal defendants in these positions adopt these sorts of arguments.
What you mean by that is we have a bunch of sovereign citizen cases.
And especially in the criminal justice system, where this court has recognized that when a defendant is essentially up against the wall, the government has a very strong case against him. Sometimes the defendants resort to defiance instead of defense. And although those of us in this room would probably do things differently, that's a defendant's choice to make. And the Supreme Court emphasized that in Ferretta, that a defendant has the right to represent himself, even if it's to his own detriment. This court has put it a little more colorfully, that defendants have the right to go down in flames if they want. And I note that the way the defendant defended himself at trial, or the lack thereof, was unusual, to be sure, but it was perfectly consistent with the arguments that he made throughout. He really never presented a defense, a factual defense. He never argued, I didn't do these things. Throughout, he was consistently objecting to the court's jurisdiction, saying that the court doesn't have the authority to proceed without my consent. The court doesn't have jurisdiction. And I mean, he really pursued that very consistently. And I mean, I hesitate to say effectively, but it was at all times consistent with his theory. He had a particular view of the law. He's not a person who lacks intelligence. He has no history of mental health issues. So really, this is a circumstance where a defendant is entitled to represent himself, even if that's to his own detriment. And courts are are required to respect that choice.
Is that lack of any mental illness? What are you thinking about, the PSR?
Yeah.
Okay.
But as well, I mean, that's another circumstance where the district court's front row seat comes into play, because as this court observed in Balsinger, the district court has the ability to gauge the defendant's understanding. When courts have interactions with the defendants in person, that's often a circumstance where if they do have concerns about the defendant's competence, about whether he actually understands and is capable of rational thought, that's a circumstance where the district judge would be able to observe that and then act accordingly. But here, none of the parties, including the defendant's standby attorneys, his prior appointed counsel before he waived counsel, the government, the district court, the multiple different judges he appeared before, none of them expressed competency concerns. And on top of that, that's not something the defendants raised on appeal, so I don't think it's properly before this court. I'd be happy to answer any
Mr.
of your other...
Kinstra, one question, something I've been kind of wondering too. So in a situation like this where someone that espouses sovereign citizen beliefs goes to trial, elects to represent himself, and then basically does nothing during the trial, doesn't really contest any of the witnesses, doesn't take advantage of his right to cross-examine, basically doesn't do anything. Would it have been within the district court's discretion to appoint counsel, notwithstanding his insistence on representing himself?
No. So that's the secondary argument that the defendant makes on appeal. It would not have been within the court's discretion because, as this court has explained, the court's discretion to rescind a valid waiver exists only to protect essentially the integrity of the proceedings against disruption. And so when a defendant declines to participate but doesn't affirmatively disrupt, the court doesn't have the discretion to rescind a waiver. I think that's exactly Banks, which rejected that same argument. And even if the court had discretion, it never has an obligation to do so. The defendant can never complain on appeal that the district court respected his wishes and allowed him to represent himself.
Okay, very well.
Thank you, Your Honors.
Thanks to you. Mr. Elevato.
Thank you, Your Honors. Just briefly, the government opens by stating that the Ferretta inquiries in this instance are insurmountable to the defendant, but that simply isn't true. First of all, the Ferretta inquiries never addressed the defendant's relationship with the third-party filer, and secondarily, the defendant's consistent arguments between the two Ferretta inquiries were what led the government in the first place to second-guess the validity of his waiver. It was at the government's suggestion that Judge Mim conducted a second Ferretta inquiry. The government stated in that motion that Jones's behavior provided no indication that he intended to participate or represent himself at trial, and that this cast grave doubts on the validity of his waiver. For the government to reverse position now and state that his behavior presented no questions about the validity of his waiver simply stretches the imagination. Thank you, Your Honors.
Okay, Mr. Elevato, thanks to you. It's a privilege to have you appear in front of us today. Mr. Palmer, it's always nice to see you. We appreciate your support. We appreciate the Notre Dame Law School Clinic taking on a case like this. Mr. Canestra, thanks to you. We'll take the appeal under advisement. The court will stand in recess for 5 minutes. of the morning, appeal number 2118, Davis versus the Illinois Department of Human Services. Ms. Lindsay, good morning.
May it please the court. I'm Tammy Lindsay, and along with Danny Wyndham, we represent the plaintiff appellants Diamond Davis and Antoinette Burns. This matter comes before this court on appeal of the district court's grant of summary judgment. This case involves the interpretation of the Family Medical Leave Act. The issues presented are as follows. Whether Davis, a pregnant female approved for FMLA due to pregnancy, was entitled for qualifying leave for morning sickness, notwithstanding the medical certification that stated Davis would only need leave for one prenatal visit a month. Second, whether Davis was required to comply with the employer's paid substitution leave policy in order to take FMLA leave. In order to be eligible for FMLA, there needs to be a serious health condition that makes an employee unable to perform functions of their employment. If the serious health condition is pregnancy, the regulation also provides that a pregnant female is able to take FMLA leave for any incapacitation due to a pregnancy-related illness.
Ms. Lindsay, in the interest of time, would you mind if I ask you a pretty detailed factual question?
Go ahead.
Okay. The FMLA leave was approved on June 1 after Dr. Mahoney submitted her certification,
Yes.
and it was approved to date back to May 4th.
Yes.
Okay, so that means that it covered the absences that your client had on May 5 and May 6.
Yes.
What do we know about those absences? Were they morning sickness related?
Yes, they were.
How do we know that from the record?
On April 29th, Davis again was ill at work and left work early and went directly to urgent care. At that time, she learned that the reason why she had been ill was due that she was pregnant. In the record, there were several days that Davis was sick, and she didn't know the reason why. At the point that when she went to urgent care on April 29th, she understood that the reason was because she was pregnant.
No, I understand that. How do we know, though, that May 5 and May 6 were morning sickness absences as opposed to, another doctor's appointment? Where do we, because we don't even have her testimony before the Civil Service Commission.
Right, Your Honor, we don't have the full record of the Civil Service Commission, but in the record, even in the opinion in which the commission, the facts that the commission found that the doctor, when she was told that she was pregnant, recommended, because she was having the morning sickness, recommended that she miss the next couple of days. So you see in her attendance record, she was out on the 5th and those days following. Because she was out 3 consecutive days, that's what she got the application for apply to apply
Okay,
for.
I got it. I understand. Thank you.
Okay. The absence at issue is the May 12th. On May 12th, Davis notified Rebecca Irby, the administrative assistant, to the manager that she felt ill pertaining to her pregnancy and she needed to leave. The district court held that Davis, in looking at her medical certification, was only approved for FMLA leave for 1 doctor visit per month, and that she necessarily meaning she was not approved for any periods of incapacitation. Clearly, that is contrary to the law. According to the regulations, a pregnant female was entitled to leave for any periods of incapacitation due to the pregnancy-related illness. When the
Why didn't the certification say that then? It makes sense to me what you're saying, but why didn't the certification say she's approved for intermittent leave? She may have complications due to conditions related to pregnancy, which, by the way, no doctor can predict. I mean, there could be 100 things that, 100 things that happen during a pregnancy that could cause intermittent.
Well, and that was our position. By virtue of being approved for pregnancy, it automatically included.
But what about Crohn's disease? What about cancer? What about heart disease?
Well,
Where do we draw the line and say, okay, if you have Crohn's disease, we know there are these side effects of Crohn's disease. And if you're only approved for FMLA leave for one doctor's visit a month, that includes every other potential side effect or condition caused by Crohn's disease.
The difference of Crohn's disease is that Crohn's disease is a chronic illness that there are times where it is passive and is not active, and there are times where they're in a flare-up. With respect to pregnancy, when you're pregnant for the entire duration.
Yeah, you're either pregnant or you're not, right?
Pregnant or you're not. So there's not going to be a period of not being pregnant. The district court interpreted the medical certification to mean that the doctor had considered morning sickness, but as the judge said, I believe the regulations imply that possibly the female was better determined whether or not she was going to be sick enough that would prevent her from working, and that a medical professional, including an OB-GYN, would not be the best person. If there was some question of whether or not Davis was in fact ill due to morning sickness, and we believe there's not. We believe there was plenty of days that Davis called off for work, including May 11th, the day before May 12th. Davis called off for work and went to see her doctor because she was ill due to her pregnancy. The employer was well aware that Davis was missing work because of morning sickness, so if they thought that the certification was insufficient, then the employer had the responsibility to go back and to question the doctor whether or not, if she was missing work because of this, would that entitle her to an absence?
And did Shapiro ever do that? Did Shapiro ever go back to Ms. Davis and say, we know that you have a certification of pregnancy. We see that you didn't request any intermittent time off due to morning sickness. We know that you've had some morning sickness. Can you go and provide us additional information or supplement the certification?
No, they did not. Your Honor, Shapiro thought that she was only entitled for leave for doctor visits. Periods of incapacitation, which the law allows a pregnant female to take leave for periods of incapacitation, the judge's ruling was that she was not entitled to that.
And so is it your position that prior to taking any disciplinary action, Shapiro was obligated to at least go back to Davis and say, hey, look, your certification isn't sufficient and isn't complete. Can you go provide us with additional information?
Absolutely, because the issue that Davis was suffering with was a qualifying leave. Therefore, they were responsible to go back and ask whether or not, if the doctor had considered morning sickness, would they have approved her for FMLA for morning sickness?
And when you say obligated by regulation, obligated by 305C,
Yes.
expressly obligated.
Yes.
Yeah. Okay, very well. Anything else? Okay. Thank you, Ms. Lindsay. Mr. Wyndham, you're going to do the rebuttal?
I'm going to do the rebuttal.
Okay, very well. Okay, Mr. Rush.
May it please the court, Assistant Attorney General Caleb Rush, appearing on behalf of the Illinois Department of Human Services. The department is asking this court to affirm the summary judgment in its favor. Unless the court prefers otherwise, I'm going to focus on Ms. Davis's claim of FMLA interference because there's no evidence in the record whatsoever regarding Ms. Burns' employment. So the district court was correct that there was no evidence to support that she had standing. This is notwithstanding some factual assertions that are found in the briefs on appeal, which are not supported by anything in the record.
So, Mr. Rush, can you address the questions we were asking just previously, which is why didn't Shapiro go back to Ms. Davis if Shapiro thought that the certification did not authorize intermittent leave because of morning sickness, and say, this doesn't cover what you wanted to cover, we need some more information?
There's several important reasons why the FMLA did not obligate Shapiro to ask Ms. Davis for a new or updated certification. One of the most important reasons is that all of the information that was available to Shapiro about this, including the date of the absence in question, May 12th, this all predates the doctor's certification. So Shapiro did everything that it was supposed to do under the FMLA and the regulations.
But by the time that Shapiro decided to proceed with disciplinary action, it had the certification at that point, right?
That's right.
And as Judge Scudder points out, it was dated retroactively to May 4th. And so certainly at that point, Shapiro, when it decided whether or not it wanted to discipline Ms. Davis, would have looked at the certification, would have realized that Ms. Davis had been missing work because of morning sickness, and at that point didn't have sufficient information to go back to Ms. Davis and say, hey, look, we're about to discipline you unless you provide us with more information.
I think that the FMLA did not prohibit Shapiro from doing that, but it also did not obligate Shapiro from doing that. And that's what this court has said.
Doesn't that what the section that Judge Scudder just read, 825.305, doesn't that obligate Shapiro to do that?
No, it does not. I believe that regulation is talking about when a certification is sufficient, and that regulation is talking about when a certification is sufficient on its face, and it defines the sufficiency of a certification. Does it provide the employer with sufficient information to confirm that the employee has a condition that qualifies them for FMLA leave? It talks about some other things like duration. So the state of a certification being sufficient or not certification is something that's determined on the face of the certification. It's not conditional.
Is there any case law that you know of that interprets 825.305C that way? Because what you're saying seems quite at odds with what the regulation says.
I don't have a case that I'm aware of off the top of my head, but I can say that I am not aware of a single case that says. Well, I'm sorry. I think that Stoops is probably the best case for this proposition, because there's no case that says that when an employer observes some information that an employee has a health condition, and then after that, and they have all the information they know from their firsthand observation. After that, they get the employee's doctor's certification, which Stoops says the employer is entitled to rely on, and then at that point, there's no obligation on the employer's part to request further information. This is the chronology here is a really key distinction.
Mr. Rush, can I ask you a question? As far what I understood from the record, there's no dispute here. There's no argument that the certification received had one or more entries that were not completed or provided vague, ambiguous, or non-responsive answers. At least because the 805.305C talks about complete and sufficient certification, but it defines what is complete and it defines what is sufficient. And it defines complete as one or more applicable entries have not been completed. And I thought the certification that the plaintiff had here was a completed certification, and there's no argument that the certification was insufficient as defined by the regulation. I didn't think certification is not vague, ambiguous, or non-responsive.
If I understand your question, Your Honor, I absolutely agree.
There's at least I understand your point on the timing. I think the point on the timing is the plaintiff took medical leave because she had morning sickness. Then she provided a certification that said she's entitled to leave, to medical leave, for one doctor's appointment a month. There's no requirement in the law, at least none that I'm aware of, and you can tell me there is. Is there a requirement in the law that says when the defendant, when the employer receives that certification, the employer has to say to the plaintiff, the certification that you provided does not cover your leave that you took 2 weeks ago. So you need to go get a new certification to cover that leave. The employer can just accept the certification and say, okay, fine, this is your certification. It doesn't cover your leave.
That's exactly right. The certification is absolutely sufficient on its face, and the employer was entitled to rely on it.
What about the May 5 and May 6th leave? Is that FMLA leave?
I don't think that the record establishes whether that leave was covered by.
No. It was back. So we know that the approval was backdated to May 4, right? And we know that she was out on the 29th. She was out on the 4th, 5th, and 6th, right?
I think that's right.
Okay.
And then she was out again on May 11th.
Yeah, and then in May 12 for 4 hours or something. Okay. So
right.
May 5 or May 6th, in your judgment, covered?
In my best judgment,
because the employer seems to have treated them as covered, or the employer did.
No, I don't think there's anything in the record that indicates that. The employer allowed Ms. Davis to take the time off. That doesn't mean that the employer treated it as covered by FMLA.
Yeah, see, what troubles me about this is I don't think the flare-up business and the certification has a thing to do with the pregnancy. I think it's all about lupus. And it seems impossible to me to fairly read the certification as telling somebody, an OBGYN telling somebody prospectively that you will not have morning sickness that is going to keep you out of work. That would be very surprising to me. And so I think the most likely construction of the flare-up question is that the doctor thought, is there anything about this high-risk pregnancy, high risk in no small part because of the lupus, that is going to prevent Ms. Davis from working? Answer, no. But then the employer doesn't raise any question at all. Shapiro doesn't raise any question at all about the absence on May 5 or May 6, but then all of a sudden there's a problem on May 12. And they talk about the certification. I think, what's the certification have to do with it?
Well, the certification is under the structure of the FMLA and the regulations. The certification is a crucial part of how the statute.
No, I get it at that level of generality. But when you look at a question about flare-up doesn't make any sense. I think this is the point Judge Kirsch is making. A question about flare-up makes a lot of sense to me if you're talking about asthma, arthritis, chronic back pain. We could probably name 50 others if we spent some time on it. It doesn't make a lot of sense to me in this case vis-a-vis pregnancy unless you're thinking about lupus.
I think that this is a crucial question because what we're talking about here is a carve-out that's found nowhere in the statute. For certain serious medical conditions, when the doctor certifies flare-ups may occur or not, the employer is entitled to rely on it. But for certain other medical conditions, an employer who is, not necessarily possessing any medical training for certain.
But the employer is presumed to know about 120A4, which expressly contemplates morning sickness with pregnancy. It's just a very odd. Frankly, I'm really surprised that the defendant took this position. But we're here.
This again, I refer the court to the Stoops case that says that an employer is entitled to rely on the statements in a certification. When an employer observes, oh, you needed some time off, we're granting you some time off.
Go ahead.
I see I'm out of time.
No, go ahead.
and we need that medical certification. We need the official doctor's word. That's the last word that the employer should be able to rely on. And as the Stoops case says, at that point, there's an incentive and a burden on the employee's part if they need the certification to be different.
But Mr. Russian Stoops, the employer went back to the employee and told them that, right? Told her, oh, you need to give us more information because your certification doesn't seem to cover the condition that you want to take leave for. Here, there's nothing in the record that Shapiro provided that opportunity to Ms. Davis, unless I'm mistaken. And along those lines, if I may, Judge Scudder, the FMLA reminders document, okay? In paragraph 4, it says, if a request for FMLA doc time is received and paid accrued benefit time is available to cover the absence, the employee will be required to submit the appropriate forms to utilize the paid benefit time. Repeated requests to utilize FMLA doc time prior to the exhaustion of paid accrued benefit time may result in disciplinary action. Is there anything in the record that would suggest that Ms. Davis had engaged in repeated requests to invoke the FMLA when she had accrued benefit time that would otherwise apply?
I'm not sure if that's in the record, but what is in the record?
Well, I mean, the reason I ask is because I'm reading from Shapiro's own policies, right? And, I think a reasonable reading would be that if an employee was seeking FMLA time and he or she had accrued benefit time, that the employee would be given a chance to submit appropriate forms to explain that, and that even if that person didn't, that person would only be disciplined after repeated requests to do so. And so I didn't see any evidence in the record that Ms. Davis had engaged in such repeated requests.
The FMLA allows employers to enforce their standard policies for requesting, days off.
Right, and that's why I'm wondering whether Shapiro followed its own policy here.
And Shapiro absolutely did follow its own policy, because the fact that the policy warns about repeated requests, repeated inaccurate requests about using FMLA time, it doesn't mean that an employee with a long history of many time and attendance abuses over a short employment history but a long serial record, it doesn't mean that gets wiped clean and all of a sudden the employee cannot be subject to discipline for yet one more time and attendance abuse after this long record.
To me, that makes sense, except for the fact that we're dealing with the FMLA that has certain obligations to provide certain benefits to employees. And so I look at this policy and I think to myself, what about an example where an employee took 4 hours of FMLA time, thought the employee had 4 hours of accrued vacation time, but didn't have any other accrued benefit time, okay, and only had 3. And so then she is required under the law, or is able under the law, to take 1 hour of non-paid FMLA time. But even in that situation, Shapiro would qualify that as an unexcused absence because of the employee's error in putting down the amount of time that she thought she had. And so why isn't that, in that hypothetical, why isn't that interference with the employee's ability to use FMLA time?
I don't think that the court needs to reach that question in this particular case, but I'll also refer the court to the district court statement, which we stand by, which is, if in fact Ms. Davis had been entitled, had exhausted her paid leave and had been entitled to unpaid FMLA time, then maybe there might have been an FMLA interference case that could have gone to trial. But that was not the case here, and I want to be clear. We're talking about 2 separate and independently sufficient reasons in support of summary judgment, because on the certification issue, what we're doing is what Ms. Davis is doing is she's asking employers to second guess the doctor's, explicit statements in the certification.
And you rely upon the flare-up language for that.
And we do rely upon the flare-up language for that, and there's nothing in the FMLA or any case interpreting the FMLA that suggests that for some medical conditions, but not others, that the employer should doubt the flare-up language. On the contrary,
Other than the regulation telling pregnant employees that they're entitled to FMLA leave for morning sickness.
it's a regulation that regulation says that is a possible eligible condition. But that regulation does not contradict the statutes and regulations that say the medical necessity for FMLA leave for a flare-up requires a medical certification. That overall statement is not contradicted by saying that, one type of potential flare-up could be morning sickness. That the implication of that is not. Therefore, when an employee might qualify for FMLA leave based on pregnancy rather than some other serious condition, then the requirement to certify flare-ups is out the window. That's simply not what the regulation says. And then, of course, there's the separate independent reason, which is that Ms. Davis had reached the 12th stage of progressive discipline according to a policy that applied equally to all of the employees, and which this court has recognized in multiple cases based on the FMLA regulations. Employers are entitled to enforce equally.
Mr. Rush, just getting back to my hypothetical, you said we don't have to deal with it in this case because the facts are different. But the reason I bring it up is because the FMLA reminders states exactly that procedure at the end of paragraph 3. If the employee does not have the requested accrued benefit time to cover the absence will remain unexcused whether or not it is an FMLA-related absence, and disciplinary action may be taken. So that specifically contemplates the example or the hypothetical that I gave you.
Yes, it does contemplate the hypothetical that you gave me, and if Ms. Davis had exhausted all forms of paid leave, I don't think we would be here today. But that's not the case before the court today, and I really do want to emphasize that when Shapiro warns employees, okay, in the FMLA reminders, okay, you got to be on top of these benefit times, and it refers to its general policy 6.2, which applies to all employees. You've got to be on top of these benefit times, and if you put in a request wrong, we have the deposition testimony of the Human Resources Director. When you put in a request wrong, it creates a massive burden for the whole system. So we really need you to get this right. First violation, you're not going to get fired. Second violation, you're not going to get fired. Third, et cetera, et cetera. But you have a series of 12 attendance and tardiness problems. Then ultimately, discharge is appropriate. It's not prohibited by the FMLA, and the fact that there's a warning does not all of a sudden erase this past track record.
Okay, Mr. Rush. Any further questions? Okay, thank you very much. Appreciate it.
Thank you for the time.
Oh yeah, no problem. Mr. Wyndham.
Good morning, Your Honors. May it please the court, I'm Danny Wyndham. I'd like to address a couple of issues that was raised during my opponent's argument. First of all, with respect to Stoops, in that case, the medical certification said that Mr. Stoops' condition would not render him unable to do his job. Second of all, this court's decision in the Hansen decision essentially says when there's a certification, the certification is an estimate. And if the employee's actions are such that they're taking more leave that's stated in the certification, the employer has a right to request a recertification. Okay? Shapiro could have done that in this case. They could have told Ms. Davis that her certification did not cover morning sickness. They did not do that. What they did was they immediately proceeded to fire her.
Did they have to do that under the law?
Yes, they had an affirmative duty to
What regulation says that?
off the top of my head, I think it's 115, but I'm not sure. It might be 305 that you discussed earlier. But they do have a duty to go back and say to the employee that, hey, your certification is inadequate. You need to provide us with some more information. In any event,
It seems to me they interpreted the certification to allow a leave for morning sickness on May 5 and May 6, but then all of a sudden somehow it was problematic on May 12th.
that's correct. It was. But here's the thing.
I don't understand that at all.
What they do, Your Honor, is they don't consider the leave as FMLA leave. All of the leave that employee takes as FMLA is designated as some form of paid leave. If you look at the records, and the employee records, time records, and they're in the record, we had a sample of 48 employees who had taken qualified FMLA leave. In each and every case but 3, all of the time that was taken for FMLA leave was designated as whatever accrued paid leave that the employee has substituted.
Did Shapiro account for them to be used concurrently, or is it consecutively? So in other words, can you, because I see in the records on Shapiro's procedures about paid FMLA leave, right?
Right.
And so when you use accrued benefit time for paid FMLA leave, I take it they're viewing both as being used concurrently.
We take issue with that. We believe that they view it as being consecutively because that's what their records state. There are payroll records and there are time and attendance records in the record, okay? And if you compare the employee's request for FMLA leave on the form, they will put sick or holiday or vacation in FMLA. But on the official records of the state of Illinois, all of the leave is designated solely as accrued paid time. None of it is designated as FMLA leave, and none of it is designated as paid leave and FMLA leave.
Mr. Wyndham, let me ask you a hypothetical question. If an employer has a policy that says you have to accurately record your time off, and it's legitimate policy because human resources is not going to fly spec timesheets, and they don't want to pay employees for vacation time that the employee doesn't have, okay?
Correct.
So let's say an employer has that policy. You have to accurately record your time off. So pay period 1, the employee takes 4 hours of vacation time, and the employee doesn't have 4 hours of vacation time. The employer calls the employee and says, you don't have 4 hours of vacation time. You can't take vacation time. The employee says, FMLA, I'm covered. It's unpaid FMLA leave. Pay period 2, the employee does the exact same thing. Employer calls and says, you can't do this. You can't inaccurately record your time. And you've again recorded it as paid vacation time, which you don't have. The employee says, I'm covered by the FMLA. Third pay period, the employee does the exact same thing. The employer calls the employee and says, you've done it now 3rd time, okay? You've violated our policy the 3rd time, you're fired. The employee says, you actually can't enforce your policy at all. It means nothing to me because under the FMLA, you've now interfered with my right to take FMLA leave. So you've got an employee in pay period 1, pay period 2, pay period 3, inaccurately records their time, attempting to get paid for time, vacation time that the employee does not have. Is the employer totally without any recourse whatsoever to enforce its policy so long as the employee has an FLA certification?
Basically, yes, because Section 207...
in order to find for you, we have to read the law that way, right?
That's what Section 207 expressly allows. It says that if the employee does not comply with the employer's paid leave substitution policy, the employee remains entitled to take FMLA leave They're just not entitled to the pay. That's what Section 207 says. That's what the court held in Strickland. That's a decision from the 11th Circuit which we're asking you to follow. But that's what the regulation said. That's the express language of the regulation, and that's also what the dissent said in the Allen case. That's what the regulations say. And if that's a policy with the employee misrecording or not recording the paid time, then in that situation, the employer should do what this court recognized in Brotherhood of Maintenance versus CXS. The employer should just designate the time. Whatever paid time the employee has available, the employee should designate that as FMLA time as well as paid time. And that will solve the problem. I see I'm out of time. If there are any other questions, I'd be glad to answer.
Okay, we took a little extra time with Mr. Rush. Any points you wanted to make?
Yes.
Don't worry about the red light.
Okay.
We want to be fair here.
Okay. There are 2 points I really want to make. One is, and a lot of them you've already covered, but this court should rule. Look, we're asking you to follow your own precedents, okay? We got the Barrett case, we got the Valdivia case, and we got the Ziccarelli case. Under Barrett, FMLA leave cannot be both authorized leave and unauthorized leave. It's one or the other. When they designate approved FMLA leave as unauthorized leave, that is interference. That is interference. The second thing is they knew that she was pregnant. They knew that she was sick because of her pregnancy, and they knew she couldn't do her job. That was enough to put them on notice that she was entitled to FMLA leave. That's all that was required under Valdivia and Burnett case. Notice can be constructive. They had enough information to know that she was entitled to FMLA. And the final point is this here. We want you to rule that as a matter of law, classifying approved FMLA leave as unauthorized constitutes interference. That's the basis of our class claim. Anytime an employee requests FMLA leave, is approved for FMLA leave, and takes FMLA leave, they will classify it. On the first instance, they don't have to do it 7 or 8 times. On the first instance, they designate it as unauthorized, simply because the employee did not correctly substitute the paid leave for the FMLA leave. As a matter of law, that's interference.
Okay, very well.
Thank
We appreciate the argument from all counsel. We'll take the appeal under advisement. We'll move to our next argument of the morning. It's a Social Security appeal number 22-2011. Mr. Duncan, nice to see you again.
Good morning, Your Honor. It's Switzerchowsky.
Thank you.
May it please the court. This Switzerchowsky was 50 years old at the alleged onset date with her past relevant work, medium and semi-skilled and unskilled. No transferable skills were found. Now, the briefs I've submitted, I think, do more than an adequate job of explaining the problems, the cherry picking by the ALJ, the distortion of the record at times. For example, referencing repeatedly normal gait when the record clearly indicates that there was an italic gait. But what I wanted to do is point out something that when I was reading my briefs I thought was a little lacking, and I think we as Social Security practitioners fall into that trap. I've spent most of my professional career in this system, and I know it like the back of my hand, and I assume the courts always do too, but I'm not. What we're talking about in this particular case is a very subtle issue. Okay? The ALJ found the claimant limited to light work. She was 50 years old. Under the medical vocational guidelines, Rule 201.14, which is semi-skilled, unable to perform past relevant work, age 50 to 54. She would qualify if she was limited to sedentary. What we're talking about is changing the residual functional capacity from being able to lift 20 pounds occasionally
10 pounds frequently, and standing for 6 out of 8 hours, to standing of 2 out of 8 hours, and lifting 10 pounds occasionally and less than 10 pounds frequently. It's a very subtle point. And the point by this is that we have fibromyalgia as a condition. And the ALJ does outline the medical objective evidence regarding the other problems, her spine disorders, her right elbow, her carpal tunnel syndrome, her upper extremities, her major depressive disorder. The problem is that this court, being one of the first on fibromyalgia, and subsequent, the sister circuits have said that Social Security was doing a poor job of assessing this. They created SSR 12-2P as an instruction, a manual of how an administrative law judge is to assess the record. That's what that provision says. It should be followed by the ALJ, and it specifically notes that you cannot isolate the conditions. If you have underlying medical conditions, you have to look at whether the fibromyalgia overlays and causes more significant problems than merely the objective evidence shows. And that's where we're resting this case upon, is that the judge did not do an adequate job of making that assessment. And there is a legitimate argument that she should have been found at the sedentary limitation based upon her statements, based upon the medical information. I outlined that the problems with the state agency assessments, they assessed the case before she was completely worked up on her fibromyalgia. So they mentioned that there was a diagnosis, but the actual tender point diagnosis that was done by the nurse practitioner was done after their assessments. As I also indicated, the problems were noted with the record itself. And what the judge has to do is he has to also look at the medical record and assess the fact that the condition waxes and wanes. So there may be points where she doesn't report problems, and then the next time she does. I would note that, for example, he noted no acute distress, 5 of 5 strength in the upper and lower extremities, sensation. He talks about pinprick, temperature, normal reflex. Then he says normal gait. I would point out that he cites Exhibit 4F 15 and 13F 35, and support both found intelligent gait. 12F at 7 noted an impaired gait. The Exhibit 4F, page 15, did note 5 of 5 strength, but then went on to note that she had experienced pain doing the finger to nose test, and that she had pain in her lower extremities, including, or in addition to her right arm. She was referred to pain management.
Mr. Duncan, can I take you back to the first point? Fibromyalgia is this is a difficult appeal.
Correct.
I get that. Where I get a slight bit disconnected, that you could help me, okay?
Sure.
I understand the point you're making about you can't just isolate a condition that way. You have to look at the condition and whether the fibromyalgia is intersecting with it somehow. That's the point you're making. You're saying that's as clear as day out of 12-2P.
Correct.
Okay. All right.
It's a Venn diagram.
I follow that. I think
Okay.
I do. Okay. Now, when I look at the ALJ's decision, and I look specifically at the analysis on page 27, you have it there?
I can correct.
Well, it looks to me like that's what the ALJ is doing. And I know you're going to say, well, no. And can you walk me through where it is that you see that the ALJ is not doing what you described.
You're talking about the first full paragraph?
Yeah, exactly. So combined effects are being considered. Combined effects, impairments might be greater than expected without the disorder.
Yep.
You know, et cetera. So it seems like the ALJ is at least mouthing the right words. And
Yes, he's providing boilerplate from the ruling. Where exactly in the decision does it indicate how he considered it? I mean, the only thing he has done is he indicated, I've considered it by pointing to these references that I've indicated, that she had with the gait, and then went on and talked about her daily activities, which he, again, cherry-picked. He said she could cook. Her cooking was opening a can of soup and
okay, so
eating
rather than
cereal.
do me this favor. You're putting it, and you're doing it in response to the question I asked, of course.
Sure.
But put it in the positive. Don't put it in the negative. In other words, if you were drafting this opinion, what would you have said consistent with the standard you articulated?
Okay. You would have to, first of all, look at all of the various medical issues, and that would be looking through the record and adequately and accurately conveying what the record says. And then outlining exactly that you would have to take into account days that she was good versus days that she wasn't good, and indicate I've taken into account the waxing and waning considerations of fibromyalgia, and I find that the waning situations where the symptoms are less are more prevalent than the severity. And this is the evidence I've reviewed to support that point. While she has limitations in her daily activities, these are other daily activities that she's able to perform. It could have been done better by the ALJ asking additional questions at these hearings. An administrative law judge has a duty to develop the record, specifically when we're looking at a case where he is assessing credibility, because a practitioner is going to be left in the dark trying to figure out where an ALJ is going to go with these cases unless he specifically asks or has questions or problems with something in the record, because there's just too much. We would have 5-hour hearings if, as a representative, you have to try to address every potential issue that an ALJ may have questions about. And this court has agreed with me on that point, and there's multiple cases that say duty to inquire. It's codified, if you can call a Social Security ruling codification, in SSR 16-3P, which specifically says you shall ask about treatment, you shall ask about daily activities, you shall ask. And in this particular case, there's a definite disparity between what ALJ outlines and what his actual findings are.
But Mr. Duncan, you say that, counsel would be in the dark, would have to explore all of every aspect of the record. In a sense, that's what you're asking the ALJ to do in the written opinion, right? Is to go through all the records. Stepping back a bit, fibromyalgia, because of the lack of objective medical evidence to try to diagnose it, so much of it does bear upon the credibility of the claimant,
Yes.
right? And so I recognize the fact that an ALJ has to do more of a longitudinal analysis, particularly when it comes to fibromyalgia, because of exactly that, because it waxes and wanes, et cetera, et cetera. But how much is sufficient? I mean, the rule that you're asking us to adopt is that basically the ALJ has to not only look at every single thing in the record, but explain every single thing in the record in the written opinion.
Not everything, Your Honor, has to be explained, but there has to be enough of an explanation that you can trace the path of reasoning. And in this particular case, there are gaps. And when you add to that the gaps where there's things that were not addressed, which SSR 12-2P directs them to consider, and then combine that with the flaws or problems that he's misstated or only provided certain portions of the record, that highlights that the decision is not supported by substantial evidence. And that's the only issue in this case. So, all right, thank you.
Okay, yeah, we'll give you a minute or so for rebuttal. Appreciate it. Okay, we'll hear from the Commissioner's Counsel.
Good morning, Your Honors. May it please the Court, Margaret Sabota on behalf of the Acting Commissioner of Social Security. I wanted to start with a few points raised by Mr. Duncan during his argument, the first of which is a critical one to this case, and that is the fact that the administrative agency physician on reconsideration did review Ms. Burr's tender point evaluation before he issued his prior administrative medical finding. And that prior administrative medical finding, along with the initial one, provides substantial evidence support for the ALJ's decision that Ms. Switzerchowsky was limited to a reduced range of light work. Following up on Judge Lee's question, I also wanted to address the question of how much is enough in an ALJ decision. And this court has said before that an ALJ's decision need not be perfect. Its reasoning need only be easily discernible for review. And that is exactly what the ALJ's decision does here. Ms. Switzerchowsky filed for disability insurance benefits for a variety of physical and mental impairments, but in this appeal put a spotlight on her fibromyalgia. And in assessing the about 400 pages of medical records in this case, the ALJ went through all of those different physical impairments, her mental impairments, explained how the findings on physical exam were mixed, specifically said that at pages 26 and 27, I believe, of his decision. Sometimes she had a normal gait, sometimes she had an abnormal gait, sometimes she had full muscle strength and tone, sometimes she had poor findings on exam. And that takes into account the waxing and waning symptoms that Mr. Duncan discussed. I'd also like to point out that as recently as January of 2020, the ALJ cited a record from neurologist Kaufman, who Ms. Switzerchowsky consulted on for her right arm issues, where she was found to have 5 out of 5 muscle strength, completely normal muscle tone in both arms. Regarding Mr. Duncan's statement that now that Ms. Switzerchowsky is resting his case on this overlay of fibromyalgia with respect to her other conditions, I don't believe that that's what his briefing to this court or to the district court focused on. The ALJ, as Judge Scudder pointed out, very clearly discussed her fibromyalgia in combination with other impairments. And I'd also like to note that in Ms. Switzerchowsky's brief, she stated repeatedly that fibromyalgia, quote, may cause additional problems, but doesn't cite to any evidence in the record that her fibromyalgia, on top of other physical conditions, did cause additional problems in her case. And as with any Social Security disability case, it's the claimant's burden to present sufficient evidence to satisfy the standard of disability. And with respect to Mr. Duncan's statement of this light work versus sedentary work being dispositive, while that may very well be the case under the medical vocational grid rules, it nevertheless is Ms. Switzerchowsky's burden to establish that she was limited to sedentary work. And on the record here, the ALJ's findings are easily discernible, supported by substantial evidence, and free from legal error, and we'd ask this court to affirm.
One of the points one of the pieces of evidence that's relied upon for the sedentary restriction, is it not, is nurse practitioner Burr's completion of the checklist?
Yes, Your Honor, the checkbox forms.
Checkbox form that way. Was, there's a point that I think you make in your brief that particular position was never presented to the district court.
Yes, Your Honor. Both the prior administrative medical findings and Ms. Burr's opinions were not raised by Ms. Switzerchowsky before the district court and should be deemed waived.
Do you know, I thought I had this here, but I can't find it. When was she diagnosed with fibromyalgia?
There was an assessment by her pain specialist, Dr. Gautam, in August of 2018. That's at record 519.
August of 2018?
Yes, so a couple of months before her amended onset date. When she had originally applied for benefits, her initial alleged onset date was July of 2018, but as Mr. Duncan noted, she later amended it to her 50th birthday in October of 2018.
What was her last date of employment?
July of 2018, Your Honor.
She had worked for 30 years, right?
Something like that, yes, Your Honor, as a warehouse worker.
Okay. Okay, very well. Thank you very much.
Thank you, Your Honor.
Mr. Duncan? We'll give you a minute if you have this point you want to make.
A claimant's subjective statements cannot be ignored, and that makes it even more the case in fibromyalgia cases. I've outlined in my brief on page 32, the initial brief, all of the various elements that are considered when assessing a medically determinable impairment that impact on this. Ultimately, the issue is that Mrs. Switzerchowsky indicated that she had severe fatigue and that she was tired and had difficulty. She had memory loss, she had anxiety, headaches, insomnia. She had side effects of her medications, which I outlined in the reply brief, were substantial. Nortriptyline is notorious for having rather severe side effects, in addition to the pain medications. And I don't see where there's an assessment by the ALJ of the pain medications or any of these other medical findings that are in the record that show that she was complaining of fatigue or other associated points. And that's ultimately the problem. It may very well be, if this court were to remand, that we go back and the judge does the decision and denies again. I don't know. All I'm asking is that this decision does not provide sufficient basis and that this should be reevaluated based upon the ruling. Thank you.
Thanks to you. Thanks, Ms. Sabota, to you as well. We'll take the appeal under advisement.
Thank you.
Our final argument of the morning is in appeal number 222867, Ralph Lisby versus Jonathan Henderson and others. Ms. Frisser, good morning. Good afternoon.
Good afternoon, Your Honor. May it please the court, I have reserved 3 minutes for rebuttal. We are here before the court today on a 12B6 motion to dismiss, which was granted in favor of the defendants, in the context of an officer's actions while off duty causing a fatality. Preliminarily, I'd like to address the 12B6 standard. We are in a position where we're permitted to do notice pleading, meaning we are only required to state a short and plain statement of the claim showing the pleader's entitled to relief. The purpose is to give fair notice of what the claim is and the grounds upon which it rests. We're viewing the facts in the light most favorable to the plaintiff, and plaintiff's complaint should not be dismissed for failure to state a claim unless there's no doubt the plaintiff cannot prove a set of facts that would entitle her to relief.
Ms. Risser, in the interest of time, what do you think if you just go one step beyond 12B6, what do you think the substantive standard is against which we're measuring the complaint?
The substantive standard is set out originally in Lewis and has been interpreted many times, and the standard we're dealing with is deliberate indifference.
Right. So the reason I'm asking the question is there any tension in your mind at all between what we said in Hill versus Shobe and then what we later said in Flores versus City of South Bend with respect to the legal standard?
That is certainly a thing that I grappled with in preparing for this argument today, and I think some
What's
of the
your
cases,
best articulation of what's that standard?
So it depends on the whether the actions are emergent or not. In Hill, technically we're dealing with just language that did not meet the level required. So meaning they asserted negligence and recklessness with nothing more. There's a really nice footnote in the Hill case which says the key word is accident. The plaintiffs alleged an accident. So I think that's a really important thing to note. In the briefing, we call Hill and Flores bookends, and I think that's a really nice way to think about it because Hill is clearly not meeting the standard. Flores is clearly meeting the standard. And so most of the cases that we will look at today fall somewhere in the middle. And that's certainly where this case falls, somewhere in the middle. So we're dealing with non-emergent actions. He's not on duty. He's not in a chase. There's no robbery. He's not doing anything emergent. He has time to deliberate. So deliberate indifference is used when there's time to deliberate. Okay, so the question is really, under deliberate indifference, what actions shock the conscience? This is something that's incredibly fact-specific, and actually, I think the Browder case...
That's Lewis. I mean, that's what that's where you're getting that from.
Absolutely.
Yeah, but in Flores, we seem to say that a trier of fact would be entitled to find the knowledge requisite for the deliberate indifference in circumstances where there's an unjustifiable risk to human life and a conscious disregard of that risk. That's the way we framed it there. Is that correct?
Absolutely.
Okay, and so that's your view of the standard.
Absolutely, Your Honor.
Okay, and then how did the facts fit that here?
So I think that the Browder case is most helpful factually because, like I said, the Flores case is an absolutely meets that standard kind of case, and we're dealing with a case that's probably a little bit less than that in some capacity. So the Browder case actually interprets several of the cases, and it involves an off-duty officer not giving chase. Okay, and in that case, the officer was driving well over the speed limit for a stretch of miles. He runs a red light and causes a collision. That court, it's the 10th Circuit, but I think it's helpful factually in this case. That court found that the officer operated with conscious contempt of the lives of others and thus a form of recklessness. The court noted that based on the facts pleaded, a jury could find no more than negligence on the part of the officer. But we're on a motion to dismiss standard, meaning on the facts pleaded, a reasonable jury could infer something more, a conscious contempt of the lives of others, and thus a form of reckless indifference to a fundamental right. So I think that's a helpful analysis, particularly given the fact that he was not on duty at the time. He has he has time to deliberate, and he's doing it sort of for his own pleasure. So that was something that I saw your brow wrinkle. When I say
I don't know. I mean, I think what you tell me I'm wrong on this. I think what you have here is you definitely have negligence. You may have extreme negligence, and I thought that what was going to be alleged, but I just don't see it, is that he was texting, and that or texting or something's causing him to look in that rearview mirror. That way, but I don't see a fact like that.
That's something that we have not had a chance to discover yet. So at the time this motion was granted, there was discovery pending, there was a motion to compel pending. So the issue sort of before this court is, are the allegations sufficient to meet the standard to allow us to conduct discovery, to allow us to hit the summary judgment stage? It's possible that we will conduct discovery and find out, actually these actions don't meet the standard, but we should be permitted to discover the facts. In this case, the defendant is in possession of all the facts that exist, essentially. We've been able to discover a small number of facts, which are stated in our amended complaint, but we should be permitted to discover more to determine, can we meet that standard? Our position is, on a motion to dismiss, we have met the standard. We have pled...
Counsel, going back to Browder, which you says kind of is instructive in this case. In Browder, as I understand it, and as I read it, he drove 65 miles per hour on city streets for a stretch of over 8.5 miles, right? And he approached an intersection at 1:30 a.m. The light was red, but he ignored it and pressed the gas pedal anyway, crashing into a car. I mean, it seems a bit different from the case here, where the time span, at least according to the allegations, that the defendant was speeding wasn't 8.8 miles. It was just kind of a limited time span, whereas he was trying to get in, I think he was trying to get in position to get on an off-ramp, right? And so doesn't So I'm not really sure that Browder really helps you in this case.
I'll note that I've entered into my rebuttal time, but I'd be happy to answer that question.
Yeah, please do. Go ahead.
Okay, so we are dealing with an off-duty police officer driving well over the speed limit. He's on the shoulder of the road. He's not looking at the road, and the lights in the area are out.
Well, he veers into the shoulder, right? He's not driving down the shoulder.
We don't have dash cam to say one way or another. We know very little at this point. We know that that's what he's admitted to at this point. The lights are out in the area, so it's darker than usual. So I'm not saying Browder's identical factually, but I think that it's very helpful and instructive because that police officer is off duty at the time. He's making an intentional misuse of his vehicle, and that's exactly what's happening here. This police officer is not conducting any governmental action in any capacity. He's not furthering his job in any capacity. He's on his way to roll call. He's maybe late for work. So my position is simply that it's instructive. It's not identical.
Okay, you want to save the rest of your time?
Yes, sir. Thank you.
Okay, very well. Mr. Montgomery, we'll hear from you.
Thank you and good afternoon to the honorable judges. May it please the court. Travis W. Montgomery on behalf of Officer Jonathan Henderson in the city of Indianapolis, the appellees and defendants below in this matter. Bearing in mind the Supreme Court's 1976 admonition that the 14th Amendment is not a font of tort law to be superimposed upon whatever systems may already be administered by the states, the district court in this case carefully considered the legal sufficiency of the estate's substantive due process claim in light of the specific facts that the estate alleged and upon which the claim was based. And the district court correctly determined that those facts, even accepted as true, were nevertheless insufficient to establish the criminal recklessness required to sustain a 14th Amendment claim under circumstances such as this. Because the court properly dismissed the estate's Section 1983 claim in response to a motion for judgment on the pleadings, and because the estate has provided no basis upon which to disturb that ruling, the appellees respectfully request that this court affirm the order granting the partial judgment on the pleadings and remanding the matter to state court. It's clear from the argument presented today that the parties agree that the 14th...
Say that last part again. Did you say remand to the state court?
Correct. Because there is also the negligence claim that remains. So part of the order that the district court issued remanded the remaining negligence claim to state court, having disposed of all the federal claims and determining that the supplemental jurisdiction in its discretion should not be exercised given the nature of the case.
Okay.
Well, the parties agree that the 14th Amendment, under these circumstances, when an officer-involved motor vehicle accident results in death, requires a demonstration of criminal recklessness. But there have been no allegations here to support criminal recklessness. Criminal recklessness is a legal standard that's been articulated by this court and others many times, and we understand the nature of the facts that have to be pled in order to establish and meet that legal threshold. Here, they simply do not exist. Here we have an allegation simply that Officer Henderson was traveling above the posted speed limit and that he made an unlawful or improper lane change. If speeding and an improper lane change are sufficient to invoke the due process clause of the Constitution, then every time we have an accident in which there's speeding or a lane change that was improper and it involves a state actor, there's going to be an opportunity for a plaintiff to simply come in and say, we believe that that shocks the conscience. We believe that that supports a violation of the due process clause. This mere claim of negligence has now become a constitutional claim. That isn't the standard. As this court said in Hill, which was referenced during the previous argument, it is not enough to show that a state actor should have known of the danger his actions created. Rather, a plaintiff must demonstrate that the defendant had actual knowledge of impending harm, which he consciously refused to prevent. There's a piece of evidence that isn't highlighted in the briefing in this case, but that is particularly important as to that particular issue. And that is, according to the facts as alleged by the plaintiffs in this case, Officer Henderson was traveling at approximately 78 miles per hour, quote, immediately before impact with Ms. Lisby. At impact, he was traveling 55 miles per hour. So when he realized that he was about to hit somebody, he slowed his vehicle so substantially in such a short period of time that he was now going more than 20 miles per hour less than he had been before. That's the opposite of conscious disregard or a conscious refusal to prevent an accident. That is evidence pleaded by the plaintiff of an actual intent of the officer to avoid the impending injury once he recognized it.
And counsel, so this took place on the shoulder of the road, right? Kind of a major thoroughfare?
Correct. So we're dealing with a major thoroughfare with 5 lanes of travel northbound, which is the direction in which the officer was traveling, as it approaches the on-ramp to Interstate 465, which is the major interstate that encircles the city of Indianapolis.
And is there any allegations in either complaint that the shoulder at that area was regularly used by pedestrians?
No, there is no suggestion to that effect, particularly at the time in which this occurred, which was 9:24 p.m. On a night. So there's no evidence to suggest that this is something that regularly occurs, that there would be any special notice or knowledge in the defendant's possession, in Officer Henderson's possession, that there was a particular harm of which he should have been aware, nor is there any evidence that he saw either of the 2 pedestrians who were walking at that time. Because Ms. Lisby was accompanied also by Mr. Lewis, her boyfriend at the time, who was also the father of the child with whom she was pregnant. And so he's also not, as part of his complaint, offered any evidence as a witness to suggest that there was texting by the officer, that the officer wasn't paying attention, or that there were special circumstances there that should have alerted the officer to the fact that there would be impending harm as he tried to exit a major thoroughfare north and southbound onto an on-ramp of an interstate where he would be expected to travel 55 miles per hour or more. To note a couple of things that were discussed, again, we talked about Hill, we talked about the bookend cases, or those were discussed earlier, Flores and Hill. And in the court, there is no contradiction between those 2 cases. They are indeed bookends of what is clearly not a constitutional violation under these circumstances or in this context.
Yeah, I mean, I think you're definitely right. They don't contradict one another. Do you think the legal standard that's articulated in both cases is exactly the same?
I think it is exactly the same. I think the standard is the same. The way that it's approached or the way that it's identified might be a little bit different because the language is different. Because we have a collection of case law in which courts applying that same legal standard have articulated it in slightly different ways. So the articulation is different. The standard, however, is not. The standard is what it is and what it has always been. And it has been that way because we recognize that the federal courts are courts of limited jurisdiction. And they have a material interest in guarding jealously that status. That's particularly true when somebody is trying to invoke the supreme law of the land as a basis for a tort claim, which is the case here. So that standard requiring the criminal negligence or the criminal recklessness, something on the border of actual intent to harm, of conscious disregard, those are all the same standard. They just are articulated slightly differently by slightly different courts, depending on the language that they choose to use or the case that they've cited in support of that position, which is the same here. I don't want to belabor the point of the fact that the facts of this case fall well within Hill, where there was no Fourth Amendment violation, where there was driving well over the speed limit and no headlights. That was insufficient. Flores was quite different, 78 miles per hour in a 30 mile per hour zone in a residential area, speeds as high as 98 miles per hour during the chase, and another instance in which a red light at an intersection was disregarded and caused a crash into another vehicle proceeding with a green light. That's the same in Browder that was discussed. It's also in Sowers, which is discussed in that case. This case clearly is more akin to Hill there is no 14th Amendment violation based on these facts. Briefly, with respect to the discovery issue, discovery in this case, based on the record, was served in October of 2021. Responses were provided in December 3rd of 2021. The motion to compel was filed on March 11th of 2022, and that's docket 61 in the record. It was originally denied, reconsider was granted, and then an order was issued in September of 2022, which granted in part and denied in part, and required additional responses due by September 14th. So there was an opportunity to provide discovery. Some discovery was provided, but the larger issue, Your Honors, is that there has been no indication or argument from the plaintiffs, or the plaintiff in this instance, as to what information specifically would have changed the outcome here had discovery been allowed to move forward. The discovery is designed to help prove the allegations that you make. The allegations have already been made here, and there's nothing that's going to come in discovery, that could come in discovery, that would change the fact that we had an officer who was on duty, by the way, because he was going to roll call, as they have alleged at least. Nothing's going to change the fact that he did nothing more than travel in excess of the speed limit and make an improper lane change. That's what it's going to be regardless, and there's no need for discovery to further that point. My time is concluded. Thank you.
Thanks to you, Mr. Montgomery. Mr. Yep.
Thank you, Your Honor. I have a few points that I would just like to touch on. First, in our amended complaint, we do allege that the plaintiff, the deceased, was on the shoulder lawfully. Next, this is not in the record, but the officer did admit that he did not see her prior to colliding with her. Finally, the defense's reliance on Hill is misplaced because, again, that case involves allegations of an accident with no deliberate intent, with only recklessness. In this case, we've alleged that his actions were arbitrary, they shock the conscience, they're capricious, taken without good reason and with deliberate indifference, willful, wanton, and malicious, done with reckless disregard of the consequences, and they demonstrate conscious and deliberate indifference. So we've done much more than the allegations in Hill. So I do not believe that it's particularly useful other than telling us what the bookend is on the other side. If you have no further questions, I will rest on our briefs and ask that you vacate the district court's order.
Okay, very well. Ms. Risser, thank you. Mr. Montgomery, thanks to you. We'll take the appeal under advisement, and the court will be in recess.